Good afternoon to everyone. Participants are requested to please get seated. Participants are requested to please keep their mobile phones on silent mode. मेरा आप सभी से निवेदन है कि कृपया कर अपना मोबाइल फ़ोन साइलेंट मोड पर कर लें। सभी प्रतिभागियों से मेरा निवेदन है कि कृपया कर अपना स्थान ग्रहण कर लें। Participants are requested to please get seated. Thank you. A very good afternoon to everyone. Sabhi ko mera namaste. We are about to begin with our inaugural session. Thank you. I request respected Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, and officers of the registry to kindly escort the dignitaries to the dais. Dr. Mohan Yadav, Honorable Chief Minister of Madhya Pradesh, My Lord Shri Justice Jitendra Kumar Maheshwari, Honorable Judge Supreme Court of India, My Lord Shri Justice Satish Chandra Sharma, Honorable Judge Supreme Court of India, My Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice High Court of Madhya Pradesh, My Lord Shri Justice Sanjeev Sachdeva, Honorable Administrative Judge High Court of Madhya Pradesh, My Lord Shri Justice Sushruta Arvind Dharmadhikari, Honorable Judge High Court of Madhya Pradesh, Shri Prashant Singh, Advocate General High Court of Madhya Pradesh, Ms. Gauri Kumar, South Asia Representative Officer, International Trademark Association, Ms. Sarah Roberts Favell, Deputy Director, Intellectual Policy, United Kingdom Intellectual Property Office, Honorable Judges, High Court of Madhya Pradesh, Resource Persons, Shri Manoj Kumar Srivastav, Registrar General and Officers of the Registry, Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy and Officers of the Academy, Shri B.P. Sharma, Principal District and Sessions Judge Indore and Judges of the District Court Indore, members of the Bar, officers from the District Administration, participants, dignitaries present in the auditorium, members of the print and electronic media, viewers who have joined us virtually, ladies and gentlemen, warm greetings to everyone. Namaste. I, Namita Dwivedi, Assistant Director, Madhya Pradesh State Judicial Academy, welcome you all to the two-day Colloquium on Intellectual Property Rights for the Judges of Madhya Pradesh, being organized by the Madhya Pradesh State Judicial Academy in collaboration with Intellectual Property Office, United Kingdom, and International Trademark Office. It is my great honor and privilege to be holding the podium today. To mark an auspicious beginning to the inaugural event, I humbly request the dignitaries on the dais to mark the commencement of the colloquium by lighting the lamp. I would request them to please proceed towards the lighting of the lamp. Lighting of the lamp removes darkness, ignorance, and unhappiness. May this light spread the Almighty's grace and divine energy in the surrounding. Thank you, sir. Thank you, my lord. Thank you, ma'am. India, as a country, lives by the shloka Atithi Devo Bhava, meaning thereby a guest is akin to God and are highly revered. Hence, moving towards the next segment of the inaugural session, I would like to begin with the felicitation of our honorable guest. I request my Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice, High Court of Madhya Pradesh, to welcome our Chief Guest, Dr. Shri Mohan Yadav, Honorable Chief Minister of Madhya Pradesh, by presenting him a planter and a memento as a mark of our respect and gratitude. Thank you, my Lord. I now request my Lord Shri Justice Sanjeev Sachdeva, Honorable Administrative Judge, High Court of Madhya Pradesh, to welcome our Chief Guest, my Lord Shri Justice Jitendra Kumar Maheshwari, Honorable Judge, Supreme Court of India, by presenting a planter and a memento as a mark of our respect and gratitude. Thank you, my Lord. I now request my Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Judge, High Court of Madhya Pradesh, to welcome my Lord Shri Justice Satish Chandra Sharma, Honorable Judge, Supreme Court of India, by presenting a planter and a memento as a token of our gratitude. Thank you, my Lord. I now request my Lord Shri Justice Vivek Rusia, Honorable Administrative Judge, High Court of Madhya Pradesh, Bench at Indore, to welcome my Lord Shri Justice Suresh Kumar Kaith, Honorable Chief Justice, High Court of Madhya Pradesh, by presenting a planter and a memento. Thank you, my lord. I now request my Lord Shri Justice Vivek Agrawal, Honorable Judge, High Court of Madhya Pradesh, to welcome my Lord Shri Justice Sanjeev Sachdeva, Honorable Administrative Judge, High Court of Madhya Pradesh, by presenting a planter and a memento. Thank you, my Lord. I now request my Lord Shri Justice Vijay Kumar Shukla, Honorable Judge, High Court of Madhya Pradesh, to welcome my Lord Shri Justice Sushrut Arvind Dharmadhikari, Honorable Judge, High Court of Madhya Pradesh, by presenting a planter and a memento as a token of our gratitude. Thank you, my Lord. I now request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, to welcome Shri Prashant Singh, Advocate General, High Court of Madhya Pradesh, by presenting a planter and a memento. Thank you, sir. I now request my Lord Shri Justice Subodh Abhyankar, Honorable Judge, High Court of Madhya Pradesh, to please welcome Ms. Gauri Kumar, South Asia Representative Officer, International Trademark Association, by presenting her a planter and a memento. Thank you, my Lord. I now request my Lord Shri Justice Sanjay Dwivedi, Honorable Judge, High Court of Madhya Pradesh, to please welcome Ms. Sarah Roberts-Favell, Deputy Director, Intellectual Policy, United Kingdom Intellectual Property Office, by presenting her a planter and a memento. Thank you, my Lord. Moving towards the next segment of the inaugural session, I humbly request Honorable Shri Justice Sushrut Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh, to please deliver the welcome address.
Dr. Mohan Yadav, Honorable Chief Minister of Madhya Pradesh, Honorable Shri Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India, Honorable Shri Justice Satish Chandra Sharma, Judge, Supreme Court of India, Honorable Shri Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh, Honorable Shri Justice Sanjeev Sachdeva, Judge, High Court of Madhya Pradesh, Shri Prashant Singh, Advocate General, State of MP, Ms. Sarah Roberts-Favell, Deputy Director, Intellectual Policy, United Kingdom Intellectual Property Office, Ms. Gauri Kumar, Representative Officer, South Asia International Trademark Association, my brother and sister judges, resource persons, Shri Manoj Kumar Srivastav, Registrar General and Officers of the Registry, Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy and Officers of the Academy, Shri B.P. Sharma, Principal Districts and Session Judge, Indore, and Judicial Officers of the District Court, Indore, officers from the District Administration, participants, dignitaries present in the auditorium, viewers who have joined us virtually, ladies and gentlemen, a very good afternoon to one and all. It is a privilege to welcome you all to this colloquium on intellectual property rights for the judges of Madhya Pradesh. This marks the first workshop on the subject that has increasingly become a key area of litigation in our state. I extend my heartfelt congratulations to the organizing committee for addressing such an important topic, which plays a crucial role in the economic prosperity of our nation. Intellectual property rights not only foster innovation and creativity, but are also essential for economic growth and the development of sound trade relations. Under the Commercial Courts Act of 2015, intellectual property disputes are classified as commercial disputes and fall under the jurisdiction of commercial courts. A foundational understanding of intellectual property law will enable our judges to effectively manage these cases, ensuring that they are all well versed in the applicable procedures and nuances of the law. The Colloquium has been thoughtfully structured, with session 1 focusing on the fundamentals and challenges of intellectual property law, session 2 exploring enforcement mechanisms and best practices, session 3 addressing the enforcement of awards, and session 4 mapping our future directions. We are privileged to have distinguished experts and professionals from this field as our resource persons, and I extend my gratitude to the Intellectual Property Office, United Kingdom, and the International Trademark Association for their support. I am confident that these sessions will establish a strong foundation for this subject in our judicial community. It is my distinct honor to welcome our chief guest, Honorable Dr. Mohan Yadav, Chief Minister of Madhya Pradesh, and Honorable Shri Justice J.K. Maheshwari, Judge of the Supreme Court of India. His Lordship's vast experience and wisdom gained from decades on the bench serve as a great source of inspiration and motivation for all of us. We are grateful for your presence today, Lordship. I am equally delighted to welcome Honorable Shri Justice Satish Chandra Sharma, Judge of the Supreme Court of India. His Lordship's unwavering dedication to mentoring and supporting fellow judges continues to inspire us all. We are grateful for your presence today. It is particularly heartening to witness the continuous warmth and commitment of both the Lordships for the betterment of judiciary in the state of Madhya Pradesh. I also warmly welcome our Chief Minister, Dr. Mohan Yadav, our Chief Justice, Honorable Shri Suresh Kumar Kaith, who has recently taken oath. We are deeply honored by your presence on this occasion. A special welcome as well to Honorable Shri Justice Sanjeev Sachdeva, my esteemed colleague from the bench, Shri Prashant Singh, Advocate General, our resource persons, distinguished dignitaries, and all the participants. I would like to take this opportunity to encourage active participation in this workshop. Your insights, inputs, and suggestions will be vital in ensuring the success and effectiveness of this colloquium. I look forward to the wealth of knowledge we will gain from these sessions. Best wishes, and thank you all.
Thank you, my lord. Your address has set the tone for the deliberations ahead. I now request Ms. Gauri Kumar, South Asia Representative Officer, International Trademark Association, to please deliver the opening remarks.
Thank you, ma'am. Honorable Chief Minister of Madhya Pradesh, Dr. Mohan Yadav, Honorable Mr. Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India, Honorable Mr. Justice Satish Chandra Sharma, Judge Supreme Court of India, Honorable Mr. Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh, Honorable Mr. Justice Sanjeev Sachdeva, Judge, High Court of Madhya Pradesh, Honorable Mr. Justice Sushrut Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh, Respected Mr. Prashant Singh, Advocate General, State of Madhya Pradesh, Ms. Sarah Roberts-Favels, United Kingdom Intellectual Property Office, Honorable Judges and dignitaries in the audience, members of the bar, participating members of the International Trademark Association, experts and panelists, Namaste. It's an absolute privilege for me to be here today representing the International Trademark Association, also called INTA, at this important colloquium on intellectual property rights. On behalf of INTA, I warmly welcome you all. INTA is a global association of 6,500 member organizations across 187 countries. And India is of vital importance, and it is a vital part of our global community. Our presence in India is particularly strong, and INTA is proud to see India's growth and a growing role in shaping global intellectual property landscape, and today's event is a testament to that. As an organization, INTA is committed to promoting and enhancing IP laws and policy in India to foster consumer trust, economic growth, and innovation. Over the years, INTA has worked closely with the Government of India and key stakeholders, including the judiciary, to promote intellectual property rights, strengthen enforcement measures, and address various emerging issues like intellectual property rights in the digital age. The Indian judiciary has played a key role in the evolution of intellectual property laws in the country, and the contributions of Indian courts are recognized and acclaimed globally. As we gather here today, we look forward to further strengthening the collaboration between the judiciary and the global IP community to ensure that India continues to be a leader in intellectual property rights jurisprudence. INTA is also proud of its long-standing partnership in promoting intellectual property awareness and education, particularly around enforcement, with the Indian Customs and other law enforcement agencies in India, as well as children, law students, college students, and SMEs. And these efforts ensure that we collectively foster a robust IP ecosystem that supports innovation and protects the rights of brands and business owners, big and small, Indian and international. INTA is very grateful to the Honorable Chief Minister of Madhya Pradesh and honorable judges from the Supreme Court of India for supporting this important colloquium, and the Honorable High Court of Madhya Pradesh and Madhya Pradesh Judicial Academy for hosting this wonderful event. I'm confident that over today and tomorrow, we will have rich discussions that will contribute to a stronger and more resilient IP framework in the state of Madhya Pradesh and in India. Once again, thank you so much for hosting us in the wonderful city of Indore. Thank you.
Thank you, ma'am, for this informative address. Now I request Shri Prashant Singh, Advocate General, High Court of Madhya Pradesh, to please address this august gathering.
Honorable Chief Minister, Shri Dr. Mohan Yadav ji, Honorable Shri Justice Jitendra Kumar Maheshwari ji, Judge Supreme Court of India, Honorable Shri Justice Satish Chandra Sharma ji, Judge Supreme Court of India, our Honorable Chief Justice of High Court of Madhya Pradesh, Shri Suresh Kumar Kaid ji, Honorable Shri Justice Sanjeev Sachdeva ji, Honorable Shri Justice Sushruta Arvind Dharmadhikari ji, Honorable Ms. Gauri Kumar and Honorable Sarah Roberts Febel, Honorable Judges of High Court of Madhya Pradesh from Jabalpur, Indore and Gwalior, esteemed judges from the District Judiciary, officers of this great state, and I can see the Mayor of Indore, Shri Pushpamitra Bhargav ji, and Cabinet Minister Shri Tulsi Ram ji, Silawat ji, legal luminaries, experts and our friends from around the world, print and electronic media, ladies and gentlemen. It is an honor and privilege to stand before and address such an illustrious gathering. For this moment, I am reminded of a quote by Ralph Waldo Emerson: "The first wealth is health." And in the context of this colloquium, I would say that the health of a state is measured by the strength of its legal and economic infrastructure. Two forces that work hand in hand to build a prosperous and resilient future. While preparing for this colloquium, I visited the Invest MP website and other online portals, intending to gather some data for the purpose of preparing my speech. But what I truly realized, beyond the impressive figures and statistics, lies a profound transformation waiting to unfold for our state, The sheer volume of investment already committed by investors is nothing short of revolutionary. It is set to transform the destiny of Madhya Pradesh, bringing about unprecedented growth and development all across sectors of our economy. We are on the cusp of an economic renaissance, one that will elevate our state to new heights of industrial and commercial prominence. All this will be made possible through the collective efforts of many individuals and institutions. However, the bedrock, the true vision and driving force behind this transformation is owed to our Honorable Chief Minister, Dr. Mohan Yadav ji. Under the leadership of the Honorable Chief Minister, the state is advancing with unwavering determination and laser-focused ambition, propelling Madhya Pradesh towards becoming a true economic powerhouse. Our Honorable Chief Minister, Dr. Mohan Yadav ji, is not only a visionary, but also a man of action. Just yesterday, before gracing this colloquium, he was presiding over the regional industrial conclave at Sagar, which, like the previous editions, was an overwhelming success. This was the fourth in a series of conclaves that began with the sacred land of Shri Baba Mahakal Ujjain, followed by Jabalpur and Gwalior. Beyond this, 4 investment sessions have been conducted outside Madhya Pradesh, attracting foreign diplomats and global investors. This has laid the groundwork for the economic revolution and the surge in employment we are about to witness, for which we owe our deepest gratitude to our Honorable Chief Minister. Here, I would like to acknowledge the foresight of Honorable Shri Justice Sanjeev Sachdeva ji, another visionary, who had already anticipated this emerging challenge, recognizing the inevitable rise in intellectual property related litigation. Your Lordship, while holding the position of Acting Chief Justice of the High Court of Madhya Pradesh, took timely steps to ensure that our state's judiciary and legal system are well prepared. It is this foresight that has brought us all together today. This colloquium will pave the way for a future where our state is not only a destination for business, but also a stronghold of intellectual property rights protection. I express my deepest gratitude to Honorable Shri Justice Suresh Kumar Kaid ji, who has since taken over as the Chief Justice of the High Court of Madhya Pradesh. In the short time we have had the privilege of observing His Lordship's commitment and leadership, we are confident that my Lord's positive outlook and proactive approach will propel us further on this journey. Your Lordship's esteemed presence here today is a testament to His commitment, and I am certain that under my Lordship leadership, the Madhya Pradesh judiciary will continue to excel in addressing the emerging challenges of this new era. It is a great honor to welcome Honorable Shri Justice Jitendra Kumar Maheshwari ji and Honorable Shri Justice Satish Chandra Sharma ji, both towering figures in the Indian judiciary. Both of them, before their elevation to the Supreme Court, made remarkable contributions during their tenures at the High Court of Madhya Pradesh. Their visionary leadership, sharp legal acumen, and unwavering commitment helped shape the judiciary during a pivotal period of growth in our state. Their influence was instrumental in navigating the challenges we faced while laying the groundwork for the future. Even as they now serve at the highest court of our nation, their wisdom and guidance continue to resonate here, illuminating the path of our judiciary and ensuring that Madhya Pradesh remains at the forefront of legal innovation and excellence. With such leadership in the helm of our government and judiciary, Madhya Pradesh stands ready to welcome global investors with confidence, ensuring that their intellectual assets are protected and their contributions recognized. As we move forward, there are several critical areas that must be addressed to ensure we are fully prepared for the future. A detailed master plan will be required to give effect to these efforts in the most effective and result-oriented manner and to bolster our legal and administrative systems. I firmly believe that in this endeavor, our friends from the Intellectual Property Office, United Kingdom, and the International Trademark Association will join hands with us, lending their expertise to further strengthen our readiness. This colloquium is just the beginning. In this regard, I assure you that as the Advocate General of this estate, I will personally and officially ensure that the Office of Advocate General is an active participant in this collective effort. We will take every step necessary to ensure that not only government advocates but the entire bar is equipped to meet the challenges of the future. Together we will train, prepare and upgrade our legal professionals, ensuring that the state of Madhya Pradesh is not just ready but a leader in the domain of intellectual property law. Together, let us march forward with unwavering confidence and determination, embracing the bright future that awaits our great state of Madhya Pradesh. Jai Hind, Jai Bharat.
Thank you, sir, for addressing us. I now request Ms. Sarah Roberts-Pavel, Deputy Director, Intellectual Policy, United Kingdom, Intellectual Property Office, to please share her thoughts with us.
Good afternoon. I'm short. I hope that's okay. The Honourable Chief Minister Mohan Yadav, the Justice J.K. Mashwari, Judge, Supreme Court of India, Justice S.C. Sharma, Judge, Supreme Court of India, Chief Justice Suresh Kate, Madhya Pradesh High Court, Justice Sanjeev Sachdeva, Madhya Pradesh High Court, the Honourable Justice Sushrit Dharma Dakari, other Honourable Judges of the Madhya Pradesh High Court, Mr. Prashant Singh, Advocate General of the Madhya Pradesh State, Mr. Krishnamurthy Mishra, Director of the MP Judicial Academy, our colleagues from Inter as well, learned district judges, distinguished members of the bar, and ladies and gentlemen. I am truly privileged to attend this very important event and to have the opportunity to share congratulations on behalf of the Intellectual Property Office of the United Kingdom. To be part of the first gathering of so many esteemed judges to talk about Baudik Sampada, intellectual property, is a true privilege. It is an absolute passion of mine. The UK-India relationship is founded on a broad range of mutual interests, where we work closely together on various topics as diverse as education and research, energy security, climate change, through to defence and international relations. It is hugely, hugely exciting to now have the opportunity to work with such a significant gathering of judges on intellectual property. First, let me say that this is my first visit to India. And while my experiences so far are limited, my colleagues have told me that to appreciate and understand India, I should go beyond Delhi and Mumbai. So I am appreciative that Indore has been my very first place to come and to spend some time. And I have very, very much enjoyed the welcome that I've received. I was involved in the UK-India Free Trade Agreement negotiations before my move to the Intellectual Property Office. So I have met some colleagues previously from the Government of India, and we were all incredibly proud to be working together to deliver a meaningful deal for both our countries. In the United Kingdom Intellectual Property Office, our office is responsible for the intellectual property system. The IPO is tasked with the promotion and administration of the IP system and the provision and dissemination of information about intellectual property. Our activities support a wide policy ecosystem from developing small, medium and also micro SMEs to achieve their potential to empowering consumers to making informed choices in competitive markets. We have a very, very diverse remit, and we are very proud of that fact. I am aware that the UK and India share a very common goal in helping our small businesses, our SMEs, our micro SMEs to develop, and IP can be absolutely critical at developing their innovation, their investment, and both our futures. Understanding intellectual property and applying that knowledge to make informed decisions is a critical enabler, especially for SMEs, startups, along with big scale-ups, multinationals, and other corporations. The creators, innovators, and entrepreneurs of today and tomorrow need to have an IP system which supports innovation, creativity, and business growth. and in order for them to be able to maximise the benefits of their intellectual property. However, crucial to this is a good domestic intellectual property system, which needs to be underpinned by an effective and skilled judicial system to enable the enforcement of these rights, which is why I welcome the event over the next 2 days, and I feel very privileged to come. A clear legal framework lays the foundation for effective intellectual property rights. IP rights do not provide sufficient incentive to create and innovate if they are not respected. Businesses and brand owners need effective mechanisms to prevent others from free riding on their investments. And we will support always effective civil and criminal enforcement of IP rights to provide justice for rights owners and to deter future infringers. The UK Intellectual Property Office works to reduce the demand for infringing goods and services through domestic programmes, but we do also do this by working in partnerships with rights holders, law enforcement and justice systems far beyond the United Kingdom, and by helping consumers across the world understand the risks and consequences of buying counterfeit and pirated content. We can improve intellectual property around the world. I'm looking forward to hearing distinguished and honest guests share their experiences and knowledge. Thank you for inviting us to this event, and special thanks to Justice Shasteva for making this event happen. It is truly, truly groundbreaking. It is the largest gathering I've ever attended across the world of law enforcement in terms of the judicial system, and I very much welcome events such as this coming forwards as well. We truly appreciate the relationship that we have with the Indian judiciary and the government, and we do very much look forward to working together now, but continuing into the future. Thank you.
Thank you, ma'am, for offering insights into the ever-evolving field of intellectual property law. Now I would request My Lord Shri Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh, to kindly guide us with your words, sir.
Thank you. Dr. Mohan Yadav, Honorable the Chief Minister of Madhya Pradesh, Mr. Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India, Mr. Justice Satish Chandra Sharma, Judge Supreme Court of India, Mr. Justice Suresh Kait, Chief Justice High Court of Madhya Pradesh, Mr. Justice Sushrut Dharmadhikari, Judge High Court of Madhya Pradesh, Ms. Sarah Robert Favell, Deputy Director International Policy, United Kingdom Intellectual Property Office, Ms. Gauri Kumar, Representative Officer, South Asia, International Trademark Association, my brother and sister judges from the High Court of Madhya Pradesh, Mr. Prashant Singh, Advocate General for the State of Madhya Pradesh, Registrar General, High Court of Madhya Pradesh, Director, MP State Judicial Academy, Honorable District Judges, Judicial Officers, esteemed guests, distinguished speakers, participants, ladies and gentlemen. I am indeed honored to welcome you to the Colloquium for the Judges on Intellectual Property Rights. We have gathered here to explore the vital realm of intellectual property which fuels innovation, creativity and economic growth. Intellectual property rights form the very backbone of modern commerce, driving progress and competition. Yet the complexities of IPR pose significant challenges. This conference aims to address these challenges, fostering dialogue and knowledge sharing. Intellectual property right refer to the legal rights granted to creators and owners of intellectual property, including patents, trademark, copyright, trade secrets, geographical indications, and industrial design. IPR protection encourages creators to invest in research and development with the comfort that their unique ideas and creations would be safeguarded and protected. This leads to development of new technologies, products, and services, driving economic progress and improving quality of life. It also fosters competition by preventing unauthorized copying and ensuring fair market conditions. This further promotes consumer confidence as genuine products and services are distinguished from counterfeit or infringing ones. Furthermore, IPR facilitates international trade as protected innovations and brands can be safely exported and imported and licensed globally. Effective IPR protection also attracts foreign investment, stimulates entrepreneurship, and creates jobs. By securing exclusive rights, innovators can commercialize their creations, generating revenue and stimulating economic growth. Moreover, It encourages creativity in art, literature, and music, preserving cultural heritage and promoting diversity. By protecting authors and artists, rights IPR ensures that continued creation of original work. In today's knowledge-based economy, IPR has become a critical component of national competitiveness. Countries with robust IPR framework attract innovation, talent, and investment, driving sustainable growth and development. India boasts of a comprehensive intellectual property rights framework, safeguarding inventions, brands, literary and artistic work, designs and geographical indications through robust laws including Patent Act, Trademark Act, Copyright Act, Design Act, Geographical Indication of Goods, Registration and Protection Act, to name a few. India is also signatory to key international treaties like the Paris Convention, Berne Convention, TRIPS Convention, WIPRO Copyright Treaty, and Madrid Protocol. India adheres to harmonized IPR standards, streamlined filing procedures, and enhanced global cooperation. These treaties facilitate the protection of Indian IPR internationally, as well as protects international brands and fosters a conducive environment for innovation and creativity. In today's digital landscape, intellectual property and technology are inextricably linked. As emerging technologies continually rise, new challenges and opportunity for IP protection. Advances in artificial intelligence, blockchain, Internet of Things, and 5G network have created new frontiers for innovation, but they also introduce complexities in ownership, authorship, and infringement. IP laws must adapt to address issues like AI-generated content, patentability of software inventions, and cybersecurity threats. Effective IP strategies can harness technology's potential, drive innovation, and foster economic growth. India stands at an important crossroad. Our country, with its vast pool of talent, creativity, and entrepreneurial spirit, is emerging as a global hub for innovation. However, with this growth comes the responsibility of ensuring a robust legal framework to protect intellectual property rights while balancing the need for access to knowledge, public welfare, and societal progress. Judiciary plays a pivotal role in this regard, ensuring that the rights of innovators and creators are safeguarded. The state of Madhya Pradesh is known for its cultural heritage and growing industrial landscape. It is no exception to this trend. For small and medium enterprises to large industries, innovation is thriving here. The legal community, particularly in the realm of intellectual property, must rise to the occasion to provide clarity, guidance, and effective enforcement in an era where intellectual property is at the forefront of economic development. In conclusion, effective IPR protection requires collaboration and cooperation amongst governments, industries, and individuals. IPR is not just a legal concept, but a catalyst for creativity, innovation, and economic growth. Let us prioritize IPR protection, encourage innovation, and safeguard the intellectual property rights of creators and investors. As we look to the future, it is clear that IPR will play an increasingly crucial role in shaping a global economy. Let us embrace this challenge, adapt to emerging technologies, and ensure that IPR continues to fuel progress and innovation. May I inform Honorable the Chief Minister that we have judges here represented from each district, physically present, and others are virtually connected. Because of constraints of time, we could not have all of them here. And the encouragement and support that we've got from our two chief guests from the Supreme Court, they were very, very eager so that we could also promote what this state requires, a very robust commercial economy. This state, after coming here, I've realized has so much potential, both in terms of economy as well as in terms of the legal minds that we have. This state has given us one of the finest legal minds in the country. We've had the finest judges in the past, two of them adorn the Supreme Court at the moment. And I'm reminded of one of the judgments which Justice Maheshwari authored in the state of Madhya Pradesh on IPR. It's a leading judgment which is still holding the fort. And I would like to, with that, welcome all of you to this conference, and I hope in the next 2 days we are able to achieve what we gathered here to do, increase IPR knowledge and assure the global community that Madhya Pradesh is ready to handle any challenge that is thrown to it. Thank you very much.
Thank you, my Lord, for guiding us and highlighting the significance of intellectual property law in today's world. I now most humbly request my Lord Shri Justice Suresh Kumar Kaid, Honorable Chief Justice, High Court of Madhya Pradesh, to please address us on this landmark occasion.
Dr. Mohan Yadav, Honorable the Chief Minister of Madhya Pradesh, Honorable Justice Jitendra Kumar Maheshwari, and Honorable Justice Satish Kumar Chandra, Judges of the Supreme Court of India, my colleagues, Justice Sachdeva and Justice Dharmadhikari on the dais, and of the dais my colleagues, their family members, Prashant Singh, Advocate General, High Court of Madhya Pradesh, Gauri Kumar, Representative Officer, South Asia International Trademark Association, Sir Robert Feivel, Deputy Director, Intellectual Property, United Kingdom, Intellectual Property Office, my brother and sister judges of all the district courts, resource persons, Shri Manoj Kumar Srivastava, Research Journal and officers of the registry, Shri Krishna Murthy Mishra, Director, Madhya Pradesh State Judicial Academy and officers of the Academy, Shri B.P. Sharma, Principal District Sessions Judge, Indore, Judicial Officer of the District Court, Indore, Office from the District Administration, participants, dignitaries present in the auditorium, ladies and gentlemen, Namaste to all. I am honored to address this august gathering at the inaugural session of the Colloquium on intellectual property for the judges of Madhya Pradesh. This event marks an important step toward strengthening our understanding of intellectual property, which is a cornerstone of innovation, creativity, and economic development in today's world. Intellectual property is often considered the bedrock of innovation. It refers to creation of the mind, be they inventions, literary and artistic works, designs, symbols or names, and images used in commerce. Protecting these creations through IPR is essential not only to reward inventions and creators, but also to foster an environment that encourages more innovation. In our fast-paced, knowledge-driven global economy, IPR protection has become an essential driver for progress. India, despite its rich intellectual heritage, ranks relatively low on the Global Innovation Index, although we have made great strides in fields such as pharmaceuticals, information, technology, and creative industries. We must further strengthen our intellectual property regime to match global standards. According to recent reports, India was ranked 40th of 53 countries in Global Intellectual Property Index. This is a critical issue that we as stockholders in the legal system must address. Why is intellectual property so important? It is because ideas, when adequately protected, fuel innovation. In addition to the patents, trademarks also play a vital role in protecting the goodwill and identity of business. Moreover, we must not overlook the role of copyrights, which safeguard creative works in literature, music, films, and more. With the growth of digital economy, copyright law has become increasingly significant in managing the challenges posed by online infringement and the misuse of content across digital platforms. As we move further into digital age, the challenges for intellectual property law have expanded. Emerging technologies such as artificial intelligence, blockchain, and non-fungible tokens are redefining the landscape of intellectual property protections. Questions regarding the ownership of intellectual property generated creations or the protection of digital assets like NFTs are complex and involving. These issues present new challenges for the judiciary and will demand our careful consideration. For instance, when considering injunctions in IP cases, courts must carefully weigh the immediate need for protection against the potential harm to public access. In patent disputes, particularly in sectors like pharmaceuticals, an injunction could significantly impact public health. Balancing these interests requires a deep understanding of both the technical aspect of intellectual property and the social implications of our rulings. Furthermore, the enhancement of IP rights remains a challenge. Cross-border infringements, especially in the digital realm, present unique jurisdictional issues. The importance of IPR in promoting economic growth cannot be overstated. Nations that actively protect intellectual property tend to attract greater investments in the innovation. At the same time, IPR laws must strike a balance between protecting creators and ensuring public access to essential goods and services. The flexibility in Indian Patent Act, particularly in cases involving pharmaceutical products, reflects this balance. The use of compulsory licensing provisions ensures that critical medicines are available to the public at affordable prices in times of need. As we gather here today to delve deeper into the evolving facets of intellectual property law, it is vital that we as judges continue to uphold the delicate balance between innovation and public good. Intellectual property law is not static. It evolves with technological and advancements, global trade, and social needs. Our role is to interpret and apply these laws in a manner that not only protects the rights of creators and innovators, but also furthers the broader goal of justice and equality. This colloquium provides us with an invaluable platform to exchange ideas, learn from experts, and deepen our understanding of intellectual property law. As we engage in discussion over the next 2 days, I encourage each of you to consider how we, as members of the judiciary, can contribute to shaping a more robust and equitable IP regime for India. I wish this colloquium great success and look forward to the enriching discussion will follow. Thank you very much. Jai Hind.
Thank you, my lord, for your profound words of wisdom and raising issues which requires consideration. Now, I take the privilege of inviting Honorable Shri Justice Satish Chandra Sharma, Judge, Supreme Court of India, to please guide us and address us.
Dr. Mohan Yadav ji, Honorable Chief Minister of Madhya Pradesh, Justice Jitendra Kumar Maheshwari ji, Judge, Supreme Court of India, Justice Suresh Kaid ji, Chief Justice, High Court of Madhya Pradesh, Justice Sanjeev Sachdeva, Honorable Judge of the High Court of Madhya Pradesh, Honorable Justice Arvind Shushruth Dharmadhikari, Judge, High Court of Madhya Pradesh, Honorable Judges of the High Court of Madhya Pradesh and their families, Honorable Shri Tulsi Silawat ji, Cabinet Minister of the State of Madhya Pradesh, Shrimati Malini Gaur ji, हमारी मेयर रही हैं बहुत साल तक, श्री गौरव रणदिवे जी, the present Mayor Pushmit Bhargava ji, Golu Shukla ji, Mrs. Sarah Robert Feville, Deputy Director, International Policy, United Kingdom Intellectual Property Office, Ms. Gauri Kumar, officers of the registry, judicial officers serving in the district judiciary, respected advocates, resource persons for technical sessions, Honorable Advocate General, I'm sorry I was not able to. Dear participants and all other who are in attendance, members of print and electronic media, a very good afternoon to one and all. It's a matter of great pleasure to be present amongst you all today. Coming back to Madhya Pradesh is always a matter of joy, and the visit becomes even more special when a visit of the High Court is included in it. To be here today brings back a host of memories of the time spent learning in this institution, and I thank you all for having me here. It's heartwarming that the Madhya Pradesh High Court is hosting a colloquium on intellectual property laws. When an institution opens itself up for academic discourse on the issue of contemporary importance, it's a reflection of the progressive outlook of the institution and its willingness to engage with the issue of contemporary importance. The enforcement of intellectual property laws is posing fresh challenges, and a curious outlook is expected from the judicial system to meet the challenge. It is commendable that the topics chosen for this conference are in line with the contemporary challenges. Issues such as arbitrability of intellectual property disputes, criminal remedies in infringement matters, dynamic injunctions, anti-suit injunctions, etc. keep resurfacing in different forms and pose different challenges in the different jurisdictions. One session which I found to be of immense importance is a session on the interplay of intellectual property rights and technology. In the modern world, the intellectual property rights are being exploited in the digital space in more ways than we could imagine. The introduction of artificial intelligence has obliterated the line between fiction and reality. The usage of the words like virtual reality is in itself an indicator of where we are heading. No doubt, the advancement of technology comes with certain advantages for the human race. However, it is essential to circumscribe the use of technology with bounds of law. The digital space cannot be converted into a breeding ground of illegalities where anonymity and lack of direct accountability are abused to bypass the law. It is equally commendable that this conference has been designed to keep the issues of global importance in focus. By their very nature, the issues involving intellectual property disputes often transcend boundaries. This peculiar characteristic of intellectual property issues is more visible in the digital space, and therefore any discourse on the intellectual property issues would be incomplete if it does not incorporate the best practices evolved in different jurisdictions. The speakers coming from foreign jurisdictions would certainly enrich the discourse in the technical session by sharing their expertise on the subject, and I hope that the participants shall leave this conference more enriched and enlightened. As all of you have come to the city of Indore, it is the cleanest city in this country. Credit goes to Malini Gaurji, Pushmit Bhargava, and to every citizen of this Indore. I would like to request all of you, after the conference is over, to go to a place which is called as Chappan Dukane. And I would also like to inform you that there is a bazaar called Sarafa Bazaar, where you will enjoy all kind of snacks, and then you will come to know what Indore is. Indore is a lovely place. People will love you. So enjoy the Indori food and become a foodie. Thank you. Jai Hind.
Thank you, my lord, for your thought-provoking and enlightening address. I now take the honor of inviting my Lord, Honorable Shri Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India, to please deliver the inaugural address.
Honorable the Chief Minister, Dr. Mohan Yadav, Brother Justice Satish Chand Sharma, Honorable the Chief Justice, Madhya Pradesh High Court, Suresh Sketji, Brother Sanjeev Sachdeva, Brother Dharmadhikari, Brother Judges, and their better half of Madhya Pradesh High Court from principal seat, Jabalpur, Indore and Gwalior. Mr. Prashant Singh, Advocate General, State. Ms. Gauri Kumar, Representative, Office South Asia International Trademark Association. Ms. Sarah Roberts Swaville, Deputy Director, Intellectual Property Policy, United Kingdom Intellectual Property Office. Dear Judicial Officers, District Judge Indore, Registrar General, State, Director Judicial Academy. I've seen number of the Additional Advocate General has come from Jabalpur, Indore and Gwalior, Chairman State Bar Council, President High Court Bar Association Jabalpur, Indore, all representatives. In addition, in particular, I have to recognize, एक बात जरूर कहना चाहिए मुझे, it's a question of intellectual property right. So the main thing is, along with Dr. Mohan Yadav or otherwise, the representatives are here. And those representatives of the public, Malini ji बैठी हैं, Saluja ji, Tulsi Bhaiya is sitting here, Pushyamitra is no doubt is from this fraternity, though he is mayor, and the Golu ji, all are sitting here. Thought intellectual property rights, thinking intellectually property rights. Anyway, I will tell you why this conference. I will not go by all this because if I will go, I know Susrut ma'am and everyone has thrown light on the subjects. I will come on certain challenges, but prior to that, why conferences? Why colloquium? Purpose. I thought it, from Ramayana I can take one thing. It says the purpose of learning is not merely to acquire knowledge, but to impart it to others and bring peace to the world. This Ramayana says. I thought, always whenever there is a meeting of mind, it should be with a direction of peace. Rights are there, intellectual property rights are there, but the intent always, the presence of everyone, this embodies that what nuances are there by which we can go ahead towards peace. So we have to thought of it. I will put certain example. We will go to intellectual property rights and Hindu mythology. When we go to this, then verse of Rigved is the best. And it is, let noble thoughts comes to us from every corner. So I am seeing here from every corner. Legislative, administration is sitting, executive, judicial officers are sitting. So please apply this verse on the subject. Noble thoughts must come from every corner. It beautifully reflects the spirit of intellectual property, where the exchange of ideas is encouraged. Yet, creators are recognized and rewarded for their contribution. Teaching of the Upanishads says that ideas are meant to flow freely. However, intellectual property rights ensures that while ideas are shared, the innovators and creators are also respected and accredited. That is the intellectual property right. If we see, we think about ancient time, then we know we are copying, we learn, everyone has learned by copying. But by this copying, whether any mischief was there ever? No. Nobody has thought about this rights. So what the reason was, if we see Indian culture, then the people trust on dharma and they give due credits to the owners. Therefore, they were not forwarding to this. Lord Krishna teaching is a revelation. It is difficult to imagine a world as it exists today, functioning without the existence of any form of attachment or ownership. That makes me recall about well-known Indian saint Tyagaraj from 18th century. What it is? Tyagaraj of 18th century, he was a just worshipper of Lord Rama. He was a very good musician. He sang all songs of Lord Rama. He gave his all mudra and everything. Everybody followed it, but nobody has created, nobody had thought it, whether this should not be followed or he would create a right on it. So, it was there, but in Indian culture it was not recognized. Not needed, because we would go by a dharma. So at that time it was not necessary. But now, whenever we are going in the age of the technology, when there is industrial development, when there is a right of intellectuals, then it starts and it is going on. Now it's a need of hour. If I say sometime, don't take it otherwise. If the old time Lord Shiva was there, then if the NDPS Act was there, then he may be the, you can understand. But it was not there. The region was dharma. System was different. And now we are thinking about something else. Now, I will discuss some issues, how the IPR was originated. This was in 17th century, the English philosopher John Locke, on the origin of the property rights, argues that a person who labors upon unowned resources has a natural right to the fruits of his efforts, and that the state has a duty to respect and enforce that natural rights. This approach is premised on the notion of the private property rights are crucial. If we go to the evolving landscape of IPR regime, then on the first recorded individual patent was granted in England in 1449 by King Henry VI in the UK. The patent was given to John, a glass maker, from introducing a new method of making stained glass, almost now 600 years. And now recent, you know what is the patent? In relation to the CRISPR gene editing technology in human organism. So now it changes from that 600 year. Now this is the situation. If we go to the world dynamics of IPR, then last 2 decades, it has grown tremendously. If we take India, for example, from 2000 to 3000 patent application in the 1980s per year. Now it has been constantly rise. where in the India in 2023, this is a data, there were 90,309 patent applications and 4,66,580 trademark applications. Making India one of the top 10 patent filing nation in the world. Please, it is to the judges, it is to the, I think, representatives of the public, it is to the advocates who are present here. This is a subject which may have the future. This space subject which may have a future. Thought of it. And I think that Sanjeev brought this idea of this conference of IPR, because as I remember, for IPR, it may be some NGO may have organized the conference, but I have not come across that any of the conference has been organized either by the academy or something. So it is a conference from the High Court. I think it gives a right thing. Suresh ji has supported it thoroughly. I am discussing with this issue with everyone. So I say it is very essential. I put some examples because representatives are here. You think why it is necessary. You have seen sometime from the local vendors, you will find you go to a shoe shop, you will find Reebok. But the mark was, who was the brand is Reebok. You see, you go Lakme, but you will find Lakme. This is a fight. You would see the example of the Amul girl, not example Amul girl, but what is the traditional behind it? Music, all dancing doll, everything. You know how much time he could take to recognize his right? It is not less than 20 years, thereby it could be done. We have to strengthen on so many issues ourselves. So this colloquium probably in my mind is very important. Now I am coming to the challenges. To my mind, some challenges are there which we have to keep in our mind. Number one, globalization and cross-border infringements. Sanjeev ji has touched this issue in his speech. 1. 2. Technological advancements are there. The issues such as artificial intelligence, speakers have touched this issue. This, what it is, the intelligence created content and decentralized technology regulation challenge traditional IP concept. The rise of artificial intelligence, this is the just burning topic in these days. The rise of the artificial intelligence, blockchain, digital assets poses a new questions about intellectual property ownership. Who owns the copyright when AI creates content? Who do we regulate decentralized technology? Whenever there is a technological advancement, it is always there is a challenge. And if you go to this, it is the most important challenge. And you see AI is being used. Vivek ji always use the AI, I know. But how far, how misutilization in India? I was speaking in Bar Council of India in one function. Use of technology, that too is social media platform. So use maybe, but should not go for misuse. And the misuse is first. Representatives are here, they have to thought of it. Next, online piracy and counterfeiting. Pharmaceutical advance and public interest. I will put emphasize the judgment of Novartis AG. This is judgment of this technology of Indian Supreme Court. How the Indian Supreme Court, though it is intellectual property rights of the individuals, but while interpreting section 3D of the Patent Act, Supreme Court make a twist in this. And that you will see what was this, what the Supreme Court did, it settled the law qua evergreening practices, which aims to prevent companies from extending patent protections by making tribal modifications to existing innovations. The Supreme Court, while discussing the above proposition, delved into legal position pre and post amendment 2005 Patent Act. The court thus came to the conclusion that in the cases of the medicinal and agricultural innovations, discussion have come for pharmaceuticals, medicines, but this is a swift change, certain innovations, a second tier of qualifying standard to grant the patent is required. Because why it is, however, at the same time to check any attempt to repetitive patenting or extension of the patent term on spurious grounds, taking into account the larger public interest involved with the chemical substances, pharmaceuticals, and agricultural products. This evolving approach of the Supreme Court reflects a commitment of the Indian judiciary in harnessing intellectual property as transformative power for its citizens, for collective welfare, aligning with the principles of the socio-economic justice enshrined in the Constitution. The intent was the next challenge is social media viral trend. Then next is IPR, a barring to technology transfer to fight climate change. The Glasgow Climate Pact from COP26. These are certain challenges. Friends, remember that every great invention begins with ideas. I started with the idea with a verse of Rigved. And I again say, remember every great invention begins with ideas. Let's protect and respect intellectual property to inspire creativity and change. This colloquium is timely as the rising complexity of IP cases demands collective action from the judiciary, policy makers, and legal professionals. Such conferences provide a valuable platform to exchange ideas, learn, and to explore way for strengthen IPR mechanism nationwide. Today, we are fortunate to have with us representatives from the international organizations such as International Trademark Association, INTA, United Kingdom Intellectual Property Offices. INTA engages with all stakeholders in IP and ecosystem, including the judiciary, which plays a pivotal role in protection and enforcement of the IP rights. These inputs during this colloquium will be invaluable in helping us align our system with best global practices. Collaborative engagement with international IP offices and organizations are essential in ensuring that India remains at the forefront of IP protection, while simultaneously balancing the interest of both domestic and global stakeholders. I would like to say one thing at the last. Dr. Mohan Yadav is here. He comes from a city which is known for the best judicial system, means a city of Vikramaditya. The justice system of Vikramaditya was known by everyone. What I want, I feel that during his time, the justice delivery system of Madhya Pradesh would enhance. All our judges of the High Court are here. Our district judges have joined by virtually some of them. Some of them are present here. Advocates are present. policy makers are present, not only for the purpose of the intellectual property rights. Our state should strengthen and enhance the reputation of our judicial system. We hope during his time all things would be done, and he will do all as required for our judicial system and for the benefit of our advocates also in the state. With this, I look forward to the fruitful discussions that will emerge from this gathering, and I am confident that insights shared here will shape the future of intellectual property protection in India. Jai Hind, Jai Bharat.
Thank you, my lord. Your exemplary vision has been instrumental in shaping our judicial system. I now humbly request Dr. Mohan Yadav, Honorable Chief Minister of Madhya Pradesh, to please deliver the keynote address.
बौद्धिक संपदा अधिकार विषय पर आयोजित इस संगोष्ठी में अभी अभी हमारे बीच हमारे न्यायमूर्ति माननीय माहेश्वरी जी ने बहुत अच्छे से बात रखी। मैं आपका वंदन करता हूँ, अभिनंदन करता हूँ। समादरणीय माननीय सतीश शर्मा जी, माननीय सतीश जी, चीफ जस्टिस मध्य प्रदेश, माननीय संजीव सचदेवा जी, ऑनरेबल जज मध्य प्रदेश, प्रशांत सिंह जी, सम्मानीय मंच और आप सब। मैं तिरुपति बालाजी की लाइन में लगे लोगों का एक दृश्य थोड़ा सा याद दिलाना चाहूँगा। मेरी स्थिति ये है, तिरुपति बालाजी की लंबी लाइन लगी, आजकल लड्डू का प्रकरण चल रहा है उनका। लंबी लाइन लगी, लोग गोविंदा गोविंदा गोविंदा, लंबे देर टाइम लगता है। टाइम लगने कारण से स्वाभाविक रूप से नंबर जब आएगा तब आएगा। टाइम पास करने के लिए गोविंदा गोविंदा। एक पति पत्नी नव दंपत्ति भी लाइन में लगे हैं, तो वो मालूम पड़ रहा आगे वाला पति तो गोविंदा गोविंदा बोल रहा, पीछे वाली पत्नी पता नहीं कुछ और बोल रही। तो लोगों ने ध्यान से सुना, बोल रहा आगे वाला बोले वही सही, आगे वाला बोले वही सही, आगे वाला बोला वही सही। लोगों ने पूछा ये नया नारा कहाँ से आ गया, ये तो गोविंदा गोविंदा बोलना चाहिए। तो लोगों ने उस जो आगे उसके पति जा रहा उससे पूछा कि आपकी पत्नी ऐसा क्यों बोल रही। तो उसने बहुत भोलेपन से उत्तर दिया कि देखो वो सही कह रही है। बोला हम गांव से आते हैं और हमारे यहाँ पत्नी पति का नाम नहीं लेते हैं, मेरा नाम गोविंदा वो कैसे लेगी। तो आगे वाला बोले वही सही, आगे वाला बोले वही सही। तो मुझे लगता कि मेरी स्थिति भी आ गई, इतने भाषण होगा तो आगे वाला बोले वही सही, आगे वाला बोले वही सही। अब मेरे पास बचा क्या है, जितनी अच्छे ढंग से बात आ गई मैं उसी में ढूंढ रहा हूँ अपने रास्ते। सब कुछ तो आ गया आज की इस, क्योंकि मुझे लग रहा था कि काफ़ी देर से बहुत गंभीर भी बैठे हैं। तो ऐसा लग रहा था कि माना कि चीफ जस्टिस साहब बैठे हैं, माननीय न्यायमूर्ति सुप्रीम कोर्ट से आके बैठे हैं, पर थोड़ा हम अपने आनंद में भी तो बैठे हैं। मैं इस पूरे भाव को समझते हुए बात करना। जो माननीय, मैं सोच रहा था कि मेरी शुरुआत कहाँ से करूँगा, रास्ते तो मेरे को कोई मिल नहीं रहे हैं, फिर भी मैंने कुछ कोशिश करी है, अगर गलती हो तो माफ़ करना। जब आपने ऋग्वेद की बात कही तो हमारे यहाँ कहा गया यतो धर्म ततो जय। जिस मार्ग पे हम धर्म को तलाशेंगे वहीं जय भी मिलेगी। और इसी नाते से अगर आपने विक्रमादित्य की बात कही तो विक्रमादित्य, और वैसे मैं उज्जैन से भी आता हूँ, ये बात भी सही है, संयोग से बहुत सारे कारण से अलग अलग डिग्री में, लॉ की डिग्री भी मेरे पास है, तो उसका आनंद भी महसूस करता हूँ। लेकिन मूलतः जहाँ से आता हूँ वहाँ के बारे में आपने बता ही दिया है, तो मैं इतना सा एक घटनाक्रम याद दिलाता हूँ विक्रमादित्य और बैताल का। मूलतः बैताल आज के इस सब्जेक्ट से जुड़ के आएंगे। अगर मैं बात कहूँगा, काल के प्रवाह में बहुत सारी बात ऐसी हो जाती है कि बैताल को भूत बता दिया जाता है। बैताल भूत नहीं है मूलतः। एक हमने रिसर्च सेंटर भी चालू कराया विक्रमादित्य का उज्जैन में, उसमें अलग अलग प्रकार की फेलोशिप दे करके उस सारी बातों को भी संकलित करने का प्रयास किया, लेकिन वो लंबी बातें। अभी तो मैं एक घटनाक्रम सुनाता हूँ विक्रमादित्य और बेताल के प्रसंग का, वो अपनी इस सब्जेक्ट से जुड़ेगा ऐसा मैं मान के चलता हूँ। बेताल और विक्रमादित्य के संवाद हो रहा है। बेताल को साथ में रखने के लिए विक्रमादित्य अपने प्रयत्न कर रहा है और उसको साथ ले जाने के प्रयत्न में बेताल उसको टालने के लिए एक कहानी सुनाता है। वो कहानी का सार ये है कि वो एक घटनाक्रम सुनाता है कि एक ऋषि की कन्या है और ऋषि की कन्या बहुत बुद्धिमान है, बहुत शरीर से भी अच्छी है, लेकिन उसकी अभी विवाह नहीं हुआ। उससे 3 अलग अलग लोग विवाह करना चाहते हैं और विवाह के प्रसंग में घटनाक्रम ये घटता है। एक सेनापति है, एक राजकुमार है, एक मही का वनवासी है। संयोग ऐसा होता है कि कोई घटना घटती कि बेटी का शरीर छूट जाता है, तो ऋषि उसका जंगल में दाह संस्कार कर देते हैं। अब तीनों इतना प्रेम करते थे उससे, जीते जी तो मिले नहीं थे, लेकिन फिर भी मन में धारणा बना ली। तो जब उसका दाह संस्कार हो गया, दाह संस्कार के बाद राख उसकी माँ है, तो तीनों आते अपने अपने प्रकार से, तीनों ने अपना प्लान बना लिया और वो तीनों अपने आप में प्रयास कर रहे कि वो मेरी पत्नी है, मेरी पत्नी है, मेरी पत्नी है। तीनों ने मान लिया। एक ने कुछ हड्डियाँ चुन ली, वो हड्डियाँ चुन के ले गया। दूसरे ने कुछ मुट्ठी भर राख निकाली, अपनी डब्बी में भर के वो ले गया। तीसरे ने साफ सूफ करके अपनी झोपड़ी में ही बना ली, वो वहीं रहने लग गया। ये घटनाक्रम देख करके विक्रमादित्य से बेताल पूछते कि जरा विक्रम ये बताओ कि इस तीनों में से तीनों ने अपने अपने ढंग से रास्ते चुन लिए हैं, अब ये सही अर्थ में पत्नी किसकी हुई? क्या राख चुनने वाले की, हड्डियाँ ले जा करके उसका, हमारे यहाँ जो श्राद्ध की परंपरा है, दाग देने की परंपरा, नदी में विसर्जित करने की, दूसरे ने नदी में विसर्जित कर दी। तीसरे ने तो एक अपनी झोपड़ी बना करके वहीं रहना चालू कर दिया। तो ये असली में किसकी पत्नी मानी जाएगी? विक्रम अपने ढंग से उत्तर देता है। वो कहता, बेताल तुम्हारा प्रश्न बहुत उलझावा है, लेकिन मैं प्रयास करता हूँ कि मैं सही बताता हूँ। वो उत्तर देते हैं कि देखो, जिसने झोपड़ी बना के रहना चालू करा उसकी तो बेटी हुई, वो अपनी बेटी के रूप में मानेंगे। जिसने उसकी कुछ हड्डियाँ चुन करके दाग दिया वो उसकी बहन हुई, और जिसने अपने साथ रखा वो उसकी पत्नी हुई। ये बौद्धिक संपदा से जुड़ा हुआ मुद्दा है जो कल को हम सबको चुनौती के रूप में आएगा। अलग अलग प्रकार की चुनौतियों में आम तौर पर जब हम अभी न्याय की व्यवस्था को देखते हैं तो वो केवल भौतिक संपदाओं से जुड़ी एक अलग की ढांचे से हम सब चल रहे हैं, लेकिन आने वाले कल में हमको अब इन सभी चुनौतियों से सामना करना पड़ेगा, क्योंकि ये विषय जितना जटिल है उतना ही ज़्यादा जरूरी भी है। केवल जटिलता से छोड़ा नहीं जा सकता। जितनी गंभीरता के साथ इस सत्र का आयोजन करने के बारे में मन बनाया होगा, मैं मान के चलता हूँ आज के इस दौर में उतनी ही ज़्यादा आवश्यकता इस बात की है, क्योंकि अब ये न्याय से जुड़ी हुई बात जब आएगी तो जमीन, व्यापार, धन, तमाम विवादों के हमने निराकरण किए हैं और उसको करना थोड़ा सा हमारे लिए वो भी कठिन था, लेकिन हमारी न्याय परंपरा से हमारे सभी न्यायालयों ने अपनी अपनी बहुत अच्छी भूमिका अदा की है। लेकिन अब ये 21वीं सदी का समय चल रहा है, नॉलेज सदी भी इसको कहते हैं। ऐसे में स्वाभाविक रूप से वो सारी चुनौतियाँ हमारे बीच आएगी, जो नई रिसर्च, नए आइडिया, नई मेडिसिन के फार्मूले, कहाँ से क्या क्या निकल के आएगा मैं नहीं बता सकता हूँ, लेकिन ये सारी चुनौतियाँ हम सबके सामने आने वाली, और जैसी चुनौतियाँ आएंगी उसमें सबसे बड़ी संपदा ज्ञान संपदा का निर्धारण करना है। और जब ज्ञान संपदा का निर्धारण करने की बात आएगी तो स्वाभाविक रूप से हमको मालूम है कि ये जो विचार हैं, ये रचनात्मक विचारों की धारा कहाँ से निकल आए। आपने बहुत अच्छा वेद परंपरा का उदाहरण दिया है, और ऐसे में हमारे विभिन्न आविष्कार, ये सब बौद्धिक संपदा संबंधित अधिकारों की सुरक्षा के प्रश्न खड़े होंगे, तो स्वाभाविक रूप से इसमें न्यायपालिका पे हमारा वजन बढ़ेगा। और मैं मान के चलता हूँ आज के इस दौर में जब हम अपने इस विकास के तंत्र को देखते हैं लेकिन मैं धन्यवाद देना चाहूँगा यशस्वी प्रधानमंत्री श्रीमान नरेंद्र मोदी जी को, जिनके कारण से वर्तमान के दौर में पहली बार 2016 में न्याय संपदा की नीति बना करके उनने हमको इस मार्ग पर एक तरह से चलना भी बताया और सरकार के माध्यम से हमारी लाइन भी डिसाइड की। और हमने सबने देखा काल के प्रभाव में जो कठिन समय गया है, मैं न्यायपालिका को भी धन्यवाद देना चाहूँगा। जब कोविड के कठिन काल में भी हमने आधुनिक समय के साथ चलना सीखा है। इतने कठिन काल में जब सब कुछ ठप्प हो गया, जान के लाले पड़े थे, लेकिन आपने अपना धर्म निभाया, न्यायालय ने अपनी भूमिका अदा की और न्याय की उस निर्बाल रूप से बहने वाली गंगा की धारा को बनाए रखा। मैं आप सबको बधाई भी देना चाहूँगा। और बदलते दौर में आज के इस अवसर पर, चूँकि हम सब जानते हैं कि कानून और व्यवस्थाओं के आधार पर चलने वाले शासन तंत्र की कामना करते हैं, तो स्वाभाविक रूप से कानून के लिए, कानून की व्यवस्थाओं के लिए जहाँ जहाँ जो ज़रूरत पड़ेगी, सरकार के मुखिया होने के नाते से मैं आपके साथ कदम से कदम मिला के खड़ा हूँ। निश्चित रूप से मैं आश्वस्त करता हूँ आज के इस सत्र के साथ, जब आप 2 दिन में अपने में उज्जैन का एक विशेष कारण भी है, वो अमृत मंथन की नगरी भी है, तो आपके विचारों के अमृत मंथन से जो कुछ निष्कर्ष निकलेगा, निश्चित रूप से सरकार, हम और आप मिलकर के मध्य प्रदेश के परिप्रेक्ष्य में हम वो व्यवस्था बनाने का प्रयास करेंगे जिन व्यवस्थाओं की यहाँ के विचारों के बाद ज़रूरत पड़ेगी। सभी प्रकार के सत्र, सभी प्रकार की व्यवस्थाओं के साथ भविष्य की चुनौतियों को लेकर के जो जो हो सकता है वो हम सब करें, क्योंकि मेरी जवाबदारी और इसलिए भी बढ़ जाती है क्योंकि मैं भी अभी डूबा हूँ। अभी माननीय आप सब ने उल्लेख किया है कि इंडस्ट्रियल समिट अभी हम लगातार करते हुए एक नई धारा बनाने का प्रयास किया है कि हमारे लिए कानून और व्यवस्था की स्थिति बनाते बनाते हमारे राज्य की वित्तीय व्यवस्थाओं की तरफ भी ध्यान देने की ज़रूरत है। और वित्तीय व्यवस्थाओं में भी खासकर आज के ज़माने में जितने प्रकार की चुनौतियाँ हैं वो भी छिपी हुई नहीं है। हमारे तमाम प्रकार के स्टार्टअप से लगा करके अलग अलग प्रकार के व्यापार व्यवसाय से निकल कर जो इंडस्ट्रियों का रास्ता बना है, वो रास्ता भी बहुत अलग प्रकार का है। लेकिन इन सारी बातों के साथ ही हमको आगे बढ़ना है और इसी कारण से हमने तय किया, जैसे यशस्वी प्रधानमंत्री ने सरकार बनाई तब भारत 11वें नंबर की अर्थव्यवस्था पे था। अभी हम सब जानते हैं कि वो 5वें नंबर पे आया, लेकिन अभी जो 2-1 दिन के रिजल्ट आए हैं उसके आधार पर तो 4थे नंबर पे हम पहुंच चुके हैं। इसी प्रकार से हमने भी तय किया है कि हमारे अपने प्रदेश के अंदर हमारी इकोनॉमी हम डबल कर लेंगे 5 साल में, और कोशिश कर रहे हैं कि इसके साथ साथ सभी व्यवस्थाओं पे ध्यान दें। मुझे ध्यान दिलाया गया है, मैं धन्यवाद देना चाहूँगा डायस का, कि आपने कहा कि हमारे यहाँ 20 साल से लगभग हाई कोर्ट की अंदर पदों की बढ़ाने की ज़रूरत लग रही है, ताकि ये जो वर्कलोड बढ़ा है उस वर्कलोड का निराकरण करने के लिए, और इसी के साथ साथ और कई सारे अलग अलग प्रकार के सुधार की आवश्यकता भी पड़ेगी। मैं प्रत्येक जगह सरकार को आपके साथ खड़ा पाऊंगा। हमारे लिए अच्छी बात है, सौभाग्य से, कि हमारे बीच में आपका और हमारा ये जो परस्पर तालमेल है, ये सरकार के लेवल पे भी और जुडिशरी के लेवल पे भी इस तालमेल में कहीं कोई कसर नहीं, पहले भी नहीं थी, अभी भी नहीं। और ख़ास करके आज के इस समय में जब सर्वसुलभ न्याय की आवश्यकता हो, सुगमता की आवश्यकता हो, शीघ्र न्याय की बात हो, सस्ते न्याय की बात हो, सरल और स्थानीय भाषा की बात हो, और समदर्शी हो, अर्थात गरीब अमीर में अंतर नहीं करने वाला न्याय हो, और संवेदनपूर्ण हो, तो स्वाभाविक रूप से इस सब में निश्चित रूप से मिल के चलने की आवश्यकता पड़ेगी। और इसमें नई टेक्नोलॉजी की ज़रूरत पड़ेगी, और नई टेक्नोलॉजी के माध्यम से हम सब इन उद्देश्यों की पूर्ति करेंगे। मेरी अपनी ओर से इस अच्छे आयोजन की बधाई, बहुत बहुत धन्यवाद।
माननीय मुख्यमंत्री जी, आपकी प्रेरक उपस्थिति से हमें न्याय मूल्यों को और सुदृढ़ करने की प्रेरणा मिली है। आपको कोटि कोटि धन्यवाद। I now request Shri Krishnamurti Mishra, Director, Madhya Pradesh State Judicial Academy, to please deliver the vote of thanks.
Dr. Mohan Yadav, Honorable Chief Minister of Madhya Pradesh, my Lord Honorable Shri Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India, my Lord Honorable Shri Justice Satish Chandra Sharma, Judge, Supreme Court of India, my Lord Honorable Shri Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh, My Lord Honorable Shri Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh. My Lord Honorable Shri Justice Sushrut Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh. Shri Prashant Singh, Advocate General for the State of Madhya Pradesh. Honorable Judges of the High Court of Madhya Pradesh. Ms. Sarah Roberts-Favell, Deputy Director, International Policy, United Kingdom, Intellectual Property Office. Ms. Gauri Kumar, South Asia Representative Officer, South International Trademark Association. Shri Manoj Kumar Srivastava, Registrar General, High Court of Madhya Pradesh. Esteemed Principal District Judges, Officers of Registry and Madhya Pradesh State Judicial Academy, Office Bearers of AG Office and Bar Associations, members of print and electronic media, distinguished guests, esteemed participants, learned judges of district judiciary present in this hall, as well as joining us virtually. Ladies and gentlemen, good evening to all. Namaskar. As we conclude the inaugural session of our Colloquium on Intellectual Property Rights, I want to express my heartfelt gratitude to everyone who made this event possible. First and foremost, I extend my gratitude to Honorable Chief Minister, who spared his valuable time from his busy schedule. Now I extend my heartfelt appreciation to my Lord Honorable Shri Justice Jitendra Kumar Maheshwari, Judge of the Supreme Court of India, for gracing us with your presence and wisdom. Your commitment to justice and the rule of law inspires us all. Heartfelt thanks are due to my Lord Honorable Shri Justice Satish Chandra Sharma, Judge Supreme Court of India, for your valuable insights that guide us in understanding the nuances of law. I extend my sincere thanks to my Lord Honorable Shri Justice Suresh Kumar Kaith, Chief Justice, High Court of Madhya Pradesh, who has accepted our invitation and generously given their time. Your Lordship's deepest words will indeed bless us in the long run. I also wish to thank my Lord Honorable Shri Justice Sanjeev Sachdeva, Administrative Judge, High Court of Madhya Pradesh, for your contentious guidance and encouragement, which adds immense value to our endeavors. I also extend my thanks to Honorable Shri Justice Sushrut Arvind Dharmadhikari, Judge, High Court of Madhya Pradesh, for your ongoing commitment to advancing legal knowledge. A sincere expression of gratitude goes to Honorable Judges of the High Court of Madhya Pradesh. Their Lordship's presence indeed added grandeur to the occasion. I would like to express my gratitude to Shri Prashant Singh, Advocate General for the State of Madhya Pradesh, for your valuable contributions and unwavering support for legal initiatives in our state. A special thanks to Ms. Sarah Roberts-Favell, Deputy Director of International Policy at the United Kingdom Intellectual Property Office. Your insights into international practices enrich our understanding of global IP framework. My heartfelt thanks to Ms. Gauri Kumar, South Asia Representative Officer, International Trademark Association, for sharing your expertise and promoting awareness of intellectual property rights in our region. I extend my sincerest gratitude to Shri Manoj Kumar Srivastava, Registrar General of the High Court of Madhya Pradesh, for gracing us with your presence and providing support for organizing of the program. I would also like to thank Shri B.P. Sharma, Principal District and Session Judge, Indore, for his presence and logistic support here at Indore. Finally, I would like to acknowledge the efforts of officers of the registry as well as the officers of the Madhya Pradesh State Judicial Academy. Your dedication and efforts are crucial in making such events possible. I also extend my gratitude to the judges of district judiciary for their full involvement. Your presence has added warmth to the function. I also express my sincere thanks to office bearers of AG Office and Bar Association for their deep interest and participation. I convey my deepest thanks to the members of print and electronic media. However, I cannot thank everyone by name, but I must place on record appreciation to everybody who has contributed to the success of this program. Thank you all. Thank you very much.
Thank you very much, sir. We have come to the end of inaugural session. I invite all the dignitaries and esteemed participants for tea. We shall begin with the first technical session at 5:15 p.m. Thank you. All the participants are requested to remain seated for some time and only thereafter proceed for tea, please. Thank you. Participants are requested to remain seated, please. Participants are requested to remain seated. Participants are requested to please proceed for tea. Participants are requested to please proceed for tea. We will gather again for the first technical session at 5:15 p.m.
Hello, check.
रहना यहाँ पे माइक
I request all the participants to please be seated. We will start the session in just 2 to 3 minutes. Requesting the participants to please be seated. I request all the participants to please be seated. I request all the participants to come forward on the chairs. The first row of the chair is vacant. Requesting the respected participants to please be seated. Requesting the respected participants to please be seated.
Hello. Check. Hello. Check. Hello. Hello. Check. Hello.
Good evening, everyone. I request all the participants to please get seated. We are about to commence with our first technical session. I request respected Director Sir, Shri Krishnamurti Mishra, Madhya Pradesh State Judicial Academy, to please escort the dignitaries to the dais.
Should we go down and then come back up? We should go. We should go down.
I invite the resource persons to the dais. I request all the participants to get seated. I also request all the participants to please keep your mobile phones on silent mode. We are about to commence with our first technical session. Good evening, everyone. Welcome to the first technical session of this colloquium, which is Introduction to Intellectual Property, Conceptual and Legal Foundation. This session shall be chaired by Honorable Shri Justice Vijay Kumar Shukla and shall be co-chaired by Honorable Shri Justice Anil Verma, Honorable Shri Justice Milind Ramesh Farke, Honorable Shri Justice Rupesh Chandra Varshine, Honorable Shri Justice Rajendra Kumar Vani, and Honorable Shri Justice Pramod Kumar Agrawal. This session shall be addressed by the following resource persons: Ms. Sarah Roberts-Favell, United Kingdom Intellectual Property Office, International Treaties; Ms. Gillian Arendt, United Kingdom Intellectual Property Office; Dr. Yogesh Pai, National Law University of Delhi, IP Foundations and Process. I would like to begin by felicitating our honorable dignitaries on the dais. I would request Shri B.P. Sharma, Principal District Judge, Indore, to please welcome my Lord, Honorable Shri Justice Vijay Kumar Shukla, Judge, High Court of Madhya Pradesh, by presenting his Lordship with a planter. Thank you, sir. I now request Shri Mahesh Kumar Sharma, Principal District Judge, Sagar, to please felicitate my Lord Honorable Shri Justice Anil Verma by presenting his Lordship a planter. Thank you, sir. I now request Shri Vijendra Singh Rajput, Principal District Judge, Guna, to please welcome my Lord Honorable Shri Justice Milind Ramesh Farke, Honorable Judge, High Court of Madhya Pradesh, by presenting his Lordship with a planter. Thank you, sir. I now request Shri Vaibhav Mandloi, Principal Registrar Vigilance, High Court of Madhya Pradesh, to please welcome my Lord Honorable Shri Justice Rupesh Chandra Varshine by presenting his Lordship with a planter. Thank you, sir. I now request Shri Padmesh Shah, Additional Director, Madhya Pradesh State Judicial Academy, to please welcome my Lord Honorable Shri Justice Rajendra Kumar Vani by presenting his Lordship with a planter. Thank you, sir. I now request Shri Samresh Singh, Registrar IT, High Court of Madhya Pradesh, to please welcome my Lord Honorable Shri Justice Pramod Kumar Agrawal with the planter. Thank you, sir. I now request Srimati Surekha Mishra, District Judge Indore, to please welcome Ms. Sarah Roberts Favell, United Kingdom Intellectual Property Office International Treaties, by presenting her with the planter. Thank you, ma'am. I now request Srimati Archana Singh, District Judge Damo, to please welcome Ms. Gillian Arendt, United Kingdom Intellectual Property Office, with the planter. Thank you, ma'am. I now request Shri Raghavendra Singh Chauhan, District Judge Amar Patan, to please welcome Mr. Dr. Yogesh Pai, National Law University of Delhi, IP Foundations and Process, by presenting him a planter. Thank you, sir. I would request the Honorable Chair to please deliver the opening remarks.
Administrative Judge, Honorable Justice S.A. Dharmadhikari, Judge, High Court of MP, Honorable Justice Vivek Rusia, Administrative Judge, Indore Bench, Sri Prashant Singh, perhaps he has gone, Advocate General, Sri Radhelal Gupta, Chairman, State Bar Council, and other members of the State Bar Council, President of the Bar Association, advocates, the Registrar General, Sri Manoj Srivastava ji, Director, Sri Mishra ji, State Judicial Academy, Sri B.D. Sharma, Principal District Judge Indore, other Principal District Judges, judicial officers who are present here and who are connected with the VC, and my all sister and brother judges with their spouses. My brother judges on the dais who are co-chair, Honorable Justice Anil Verma, Honorable Justice Milind Phadke, Honorable Justice Vasne, Honorable Justice Rajen Vani, Honorable Justice Pramod Kumar Agrawal, and distinguished resource persons of this session, expert on the topic of Colloquium, Ms. Sarah Roberts Favell, Ms. Gillian Arnett, Dr. Yogesh Pai. Sri N.P. Singh, Principal Secretary Law. Now the Colloquium, as we have seen in the inaugural session, in fact it is based on the concept of Vasudeva Kutumbakam, which means the whole world is one family. And as we have seen that today, the participants and the dignitaries on the dais and the resource persons are not only from India, but they have also come from the United Kingdom. So this shows that this issue of today's topic of this first session, that introduction to the intellectual property conceptual and legal foundation relates not only to a country, but it is a global issue which is to be considered in this session. First of all, because the subject which is on which we are going to discuss is intellectual property. Prior to that, what we read earlier, Property in Property, Transfer of Property Act, that property means the ownership of tangible or intangible assets. And what is tangible assets? A property, we all know that those which can be seen are touched. They are tangible property, like building, land, vehicle, equipment, assets, etc. And the intangible properties are negotiable instruments, goodwills, brands, patent, copyrights, etc. Means those which are non-physical and which can't be seen are touched. So these are the property which we read in the Transfer of Property Act. Now, this concept of intellectual property refers to creations of the mind, such as inventions, literary, artistic work, designs, symbols, names, and images used in commerce. As in the inaugural session, it has been said that when it is intellectual property, then measures have to be taken for protection of these rights when they are infringed. In the Indian, and they are the basic concept which will be considered and which will be addressed by our resource persons are copyrights. And the copyrights are protects which original literary, artistic, and musical works like books, scripts, painting, poems, dialogues, etc. copyright. Patents here connotes new inventions and inventions like medicines, Bluetooth products, etc. Another word, trademarks, that protect symbols, names, slogans used to identify goods or services. The controversy, like we all know of the Bisleri, Coca-Cola, etc. had gone to the courts. That was relating to the trademarks. Another is trade secrets. That also comes within this intellectual property, which provides that protects confidential business information, practices, formulas, recipes, etc. Another is industrial designs, means protect the visual designs of objects, shape of particular design, logos, etc. And one of the most which is popularly known is GI tag, geographical indications. Geographical indications for the Madhya Pradesh, it's a Chanderi fabric which has been given GI tag. For Indore, it's a Ratlami save which has been given GI tag. Darjeeling tea of the Bengal, and one more for those who are non-vegetarian is Kadaknath chicken, which is from Jhabua in Indore division. It is also given GI tag. So now I would not take much time for this session because our distinguished and experienced resource persons will be discussing on the following issues of different types of IP rights, international treaties, brief overview of examination, process and administrative proceedings, special types of trademarks, well-known marks, and another very important is these days, bad faith registrations. So on these issues, there will be a discussion by our resource persons. And with this, I conclude. Thank you all.
Thank you, my lord. The first speaker for this session is Ms. Gillian Arendt, United Kingdom Intellectual Property Office. I would like to give a brief introduction about our resource person. Ms. Gillian is responsible for leading on the United Kingdom IPO's relationship with India and Central Asia, as well as for the policy development in these areas. In collaboration with the United Kingdom IPO's locally employed attaché based in Delhi, Ms. Gillian and the attaché manage and advance United Kingdom and India's interest on intellectual property. I request her to please address us.
Hello everyone. It is an absolute honor to be here today to address you all. Sarah and I have received such a warm welcome here in Madhya Pradesh, so we send our heartfelt gratitude to all those that made that happen. Thank you for the introduction. And you've already been introduced to Sarah. So the Intellectual Property Office of the UK is the official UK government body responsible for intellectual property rights. All the IP rights sit under one roof, including copyright. IPO is an executive agency sponsored by the Department for Science, Innovation and Technology. Our functions are equivalent to those of both the Office of Controller General of Patents, Designs and Trademarks and DPIT here in India. We are responsible for rights granting as well as policy development. Today, we will provide an overview of the IP rights from a UK perspective, touching upon the UK's application processes and administrative processes for the protection of those rights in the UK system. Yogesh Pai will then follow on, going into more detail, especially IP enforcement and making it more real in the Indian context. Oh, slides. Clicker. Next. Okay, thank you. Thank you for your patience. So thank you, Sarah, on the panel for opening this session and touching upon some of those intellectual property rights. Here on the screen, this reflects the IP rights we have in the UK and typical amongst all countries who protect IP. There can be some nuances. In the UK, we have two unregistered design rights, one which has its origin in EU law and the other introduced as a carve-out of our copyright in the late 1980s. Briefly on patents. Patents protect new inventions, how products work, technical functions, what they do, how they do, and how they do it. New, it must not have been made publicly available anywhere in the world. For example, it must not be described in a publication. Inventive, for example, it cannot be obvious change to something that already exists. And either something that can be made and used, a technical process, or a method of doing something. There is no specific time frame on how long it can take a patent to be granted. The timeline shown on the screen gives an overview of the process, the office and how our customers go through. As you will see from the diagram, it can take up to a year to receive confirmation that a patent is granted or has been refused. The orange highlighted text highlights when a payment is required from the customer. And here, next. Here is an example of the fees, just to demonstrate. So roughly 10,000 rupees for a paper application and 6,700 for an online, just as an example. Copyright and related rights. In the UK, copyright protects your work and stops others from using it without your permission. This is more global as well. You get copyright protection automatically. The moment you put your work into a fixed format, you have copyrighted it. You are not required to, but you can mark it, as you can see with the symbol of the sea. There's other pictures. It is not a requirement, but we advise that you do it. That being said, sorry. I'll skip that bit. Some EU member states, such as France and Germany, who have a civil law legal system, have an open list of protected works. For example, in the French law, copyright applies to any work of the mind, regardless of form. A closed list approach applies for greater legal certainty, but allows less flexibility. The UK system has generally moved closer to the continental model as a result of EU harmonisation and judgments from the Court of Justice of the European Union on copyright case law while the UK was part of the European Union. The general approach to copyright and related rights legislation is affected on whether a common law or a civil law system is in place. The common law copyright tradition, to which the UK belongs, views copyright more practically as a means to incentivize the creation of new works and trends that tends to favor more flexible laws. This view is in the minority compared to European states. EU copyright is influenced by the civil law, as said before, droit d'auteur tradition of the continental Europe, which holds that the creator's works should be protected as they embody their personality and that their protection is essentially a human right. This tradition is the basis of the copyright laws of most member states. Copyright does not protect works in the public domain, ideas, single words, generally titles, and generally facts. So as you'll see on the screen, we've got two books at the top, both deceased 1947. That copyright has expired. You can't protect an idea, only the execution or expression of that idea. The only way to protect an idea is to keep it secret. Single words can't be subject to copyright, but they can be trademarked. How long does copyright last? The length of copyright varies across the world. The Berne Convention sets some minimum standards which, with the exception of photographic and cinematographic works, lasts for the life of the author plus 50 years. However, nations such as the UK, EU, US, Japan and Australia give longer term of protection, generally around 70 years after the death of the author. Variances occur around the world. There are limitations and exceptions. Certain exceptions only apply if the user of the work is a fair dealing. For example, the exceptions relating to research and private study, criticism, review, quotation, or news reporting. Fair dealing is a legal term used to establish whether a use of copyright material is lawful or whether it infringes copyright. There is no statutory definition for fair dealing. It is for the courts to determine, and it will always be a matter of fact, degree and impression in each case. The question to be asked is, how would a fair-minded and honest person have dealt with that work? Factors that have been identified by the courts as relevant in determining whether a particular dealing with a work is fair include, does using the work affect the market for the original work? Is the amount of the work taken reasonable and appropriate? Was it necessary to use the amount that was taken? Designs. Registered designs protects the overall visual appearance of a product. Physical shape, configuration, or decoration. With a design registration, you are looking at the way the product looks. Nothing to do with how it is put together or what it is put together with. It is simply how it looks. In the UK, the design system is complex, as there are different types of protection that are available. Registered designs are examined, and registered by the IPO and can be viewed in a designs journal. There are also two forms of unregistered designs: supplementary unregistered designs, which they have their origin in UK law, and UK unregistered design right, which was introduced as a carve-out of the copyright in late 1980s. Both types of designs exist automatically if relevant requirements are met. Overlap with copyright, eligible designs can also be protected by copyright. Unregistered designs and copyrights come into existence automatically when the relevant requirements are met. This slide gives more detail about the different types of designs protection. Registered designs protect a product for up to 25 years, renewed every 5 years. 2D and 3D products can be protected. Criminal sanctions are available for international infringement of a registered design. Supplementary unregistered designs protect 2D and 3D appearance of a design for 3 years from first disclosure in the UK. It is automatic. Designs can be protected by copyright if the relevant requirements are met. Designs need to be considered a work of artistic craftsmanship. Term is life of the creator plus 70 years. Designs don't protect everything. Some key exclusions are shown here. Designs solely are dictated by technical function. This is because some products have to be shaped a certain way to carry out their function. For example, the prongs of a plug. The plug casing, however, doesn't need to be shaped a particular way and can be protected. Technical aspects of products are protected by patents. Designs contrary to public policy and morality, self-explanatory. Essentially, offensive material can't be protected as a design. This can be subjective. Royal emblems and coats of arms, certain emblems and national flags. Here on the screen includes criteria for a design application. I won't go in much depth, but you can see, further on. Here again, I give you an example of the customer and their experience and what the costs would be incurred if they were to apply for a design right. And trademarks. And now I will hand you over to Sarah to continue this presentation.
Thank you, ma'am. The second speaker for this session is Ms. Sarah Roberts-Favell. I would like to give a brief introduction about our resource person. Ms. Sarah is responsible for the United Kingdom Intellectual Property Office's international strategy and activity, as well as the UK IPO's network of international IP attaches. Her teams are responsible for the UK IPO's bilateral relationships and cooperation across the world, as well as the UK IPO's work with World Intellectual Property Office. Ms. Sarah has extensive experience in IP trade negotiations, having led the IP negotiations for the UK's Australia and New Zealand free trade agreements. I request her to please address us.
Hello again, and lovely to see you all again. And I do just want to say once more, thank you ever so much for inviting us. This is my first full overseas trip with the Intellectual Property Office, and it's wonderful that it's to such an esteemed gathering of colleagues and judges in India. So it's dear to my heart that this is my first trip as a formal overseas visit from the IPO. So thank you very much for the invitation. So trademarks is an area which I feel particularly passionate about because they are founded on reputation, and reputation is key to any industry, but particularly small and medium-sized enterprises and startups. Your reputation is what your whole company and what your whole industry and what all of your products are based on, and trademarks sit very firmly at the heart of that. So, a trademark. They're a badge of origin, basically, and they distinguish the goods and services of one trader from another. And they are registered for specific goods or services, and we have them within 45 separate subjects, which they're broken down into. and classes. It's possible to register identical or similar marks across a different class as long as they are in a different and unconnected class. So you might have the word polo used in a number of different trademarks by different companies for different purposes. In the UK, there is a polo car through Volkswagen. There is a polo mint, which is a sweetie. There's the polo shirt, an item of clothing, and then there's polo fragrance, as in Ralph Lauren polo. So polo can feature across many different trademarks itself. So it's all about confusion. You wouldn't confuse polo as in polo suite as in polo car. They are obviously very different products, so you wouldn't get those confused. So polo can be used as part of a trademark. The main thing is that it's about not misleading the consumer and making sure that consumers are certain about the product or the service that they're purchasing themselves. So in terms of what can be registered, a trademark must be distinctive for goods and services that you provide. So the Chanel name, the Nike logo, they're well known and they are well represented, and you would be able to identify them straight away. So there are specific ones on this list, for example, which are based around colour, and I'll come on to that shortly because colour has a different relationship within trademarks itself, so bear with me on that. But what you've got to make sure is, because colour can be protected in a different way in a trademark, just because you have set yourself a trademark with one colour doesn't mean it's protected across all colours. Your trademark might be in blue, but it doesn't mean it's protected in orange, for example. Also, the one thing to bear in mind if you're looking and trying to make a decision around a trademark on whether something is being infringed, as you've already heard from my colleagues on the stand and previously, there is a lot of interplay in intellectual property. And if you're listening and you're looking at doing a music trademark, a sound trademark, bear in mind the music may be copyrighted, so there may be other elements of intellectual property at play in one time. One product may not just be a trademark. It may involve patents, it could involve copyright, it could involve design. So intellectual property on one item can be incredibly complex, and the interplay can be very, very challenging sometimes to take apart and to investigate. So, rather similar to designs, what can't be registered? As we've said before, it obviously can't be offensive. It can't be against public morality. Again, that can be something which is down to a particular jurisdiction or a particular person's interpretation. Now, that certain protected emblems, such as the Red Cross, for example, or the Olympic rings, they can't be registered. They're already a protected symbol. In the United Kingdom, we are obviously rather sensitive around certain emblems and logos when it comes to royal crests and emblems like those. So there are particular restrictions around being able to use those as a registered trademark. Sometimes we might reject something which has been applied for as a trademark because it's considered to be too generic and in common use, and it's not specific to that one item or that one product. We had an example around some cakes in the United Kingdom. There was a company who wanted to trademark exceedingly good cakes, which is rather descriptive. And actually, most people who make a cake would rather hope that their cakes are exceedingly good. So to have a trademark of exceedingly good cakes was considered too general and too generic because it could be a description of many of them. However, the company took the rejection and they waited, and they continued to monitor the public, and they used it again and again in their advert, not as a trademark. Eventually, they could prove that that phrase was so intrinsically linked with their product that if you said it, you would straight away go, Mr. Kipling's cakes. They then were able to trademark it because it was so intrinsically linked with the reputation of their cakes and their company. If you said Mr. Kipling's cake and provided somebody with another biscuit, a bourbon biscuit, they wouldn't have been expecting that, so they could prove that the two were linked. So just because something is rejected initially as a trademark, it doesn't mean that in the future that may change. So that's something to bear in mind when looking at case law and looking at what's happened previously with judgments. Sometimes the situation may change. Trademark costs in the United Kingdom, Again, we've given you a little overview very briefly on what our costs are. We try to keep our costs as low as possible to keep them as accessible as possible. In the same way with the Indian innovations strategies, we want to be able to promote intellectual property at every level, so it's important to us to be able to keep our costs down. Now, this is my favourite area of trademarks, I'm afraid. I absolutely love the non-traditional trademarks. They are fascinating. So, when it comes to trademarks within the United Kingdom, we are looking at the Trademark Act 1994, which defines what a trademark is. So within that act, a trademark has to be capable of being represented in a manner which enables the registrar and the competent authorities and the public to determine the clear and precise subject matter. It also has to be capable of distinguishing the goods or services. Now, we then get to the Siegmund 7. The Siegmund case is what we use to determine our trademarks. And every country has two basic criteria for the registration of a trademark. One, the sign must be capable of being represented clearly, often graphical representation. It must also be capable of distinguishing the goods or services, as I said. Now, the European Court of Justice in the Siegmund versus Deutsche Patent- und Markenamt held that a non-traditional mark, although it can be visually perceived, can be registered if it can be graphically represented and able to be distinguished. We use these 7 principles when we are determining if a trademark can be trademarked or not, and it is a universal case which is used across many jurisprudence when it comes to trademarks. However, colour marks are challenging. To be able to be very specific and to tie down a trademark to say that is that specific purple. My determination of purple may be very different to my colleague Gillian's determination of purple. So when you're trying to write down that very clear, very specific definition of what that trademark is in terms of colour, we refer to what are called Pantones. So, for example, Cadbury's in the United Kingdom was a particular well-known chocolate manufacturer, and they had a very, very distinctive purple wrapper. And they wanted to trademark that purple wrapper, so that anybody with a purple on their chocolate must be Cadbury's. Very iconic, again, based on reputation. They wouldn't want another chocolate in purple not being as tasty and therefore damaging their reputation and harming their trade. But to be able to trademark the colour, you've got to be able to provide that specific Pantone reference. So this markup here is the consistence of the colour Pantone, and it's Pantone 2685C. You've got to be very specific when it comes to a colour mark. You can't just say it's blue. You've got to provide that distinguishing feature of the colour. I won't go through the Cadbury's case in too much detail, but basically it was considered in 2022, so it's quite a recent case in the High Court that this came to, and they considered that the first and the third marks were acceptable. So the colour with the Pantone, as shown in the form of application, was accepted. The third decision, the colour purple Pantone, as shown in the form of the application, again, the third part was accepted. However, the second mark, the High Court in the United Kingdom was not satisfied that the removal of predominant in the description, so they were trying to say the colour purple applied to the whole visible surface or being the predominant colour was how they were trying to describe their trademark. But the High Court in the United Kingdom decided that that was not sufficient to render it a colour sign to indicate the trade origin. It was still considered to be too vague, because predominant, well, what is predominant? What's the percentage coverage? What does that look like? So it's really important that you are very specific when looking and making decisions around trademarks as to whether it's infringing or whether it could be granted, as to how specific and detailed that description is and can be. So when it comes to the non-traditional marks, the key takeaway points when it comes to colour is you've got to have a colour code. There must not be ambiguity in a description. You can't protect multiple potential forms in different colours. You've got to list each colour. And colour is a single thing and can be seen in different ways. Hence, it's got to be that very specific description. So non-traditional marks can also look at shape. So some shapes can be protected by design, but they can also be protected by trademark. So the Coca-Cola bottle, the old style glass bottle is considered so distinctive it was able to be trademarked. The perfume of Jean-Paul Gaultier's sort of sailor figures, again considered so distinctive that they could be trademarked, because they're not generally considered to and seen by the public as trademark. They are sometimes a little more challenging to make a decision on and around. So you have to require evidence that they are distinctive before you can file a shape mark in the United Kingdom. So again, like that example around the exceedingly good cakes, they have to prove and get customer research to show that that is definitely linked to their product and their brand themselves. Now, I've already mentioned briefly, but sound marks are also a non-traditional mark which can be considered, and is often one which can lead to disputes, because you can have decisions, you have potentially interaction with copyright. So if you are looking at providing a sound mark as a trademark, then you need to be thinking very carefully, have you got the copyright for that piece as well? And if you haven't, you need to get permission and attribute it appropriately as well. We like to, in the United Kingdom, have them filed as MP3s or MP4s. We're very pro and would promote the use of electronic filing, but you could do it as an annotated script as well. In some jurisdictions, you can annotate it. Very unusual ones, but starting to become more and more, are motion marks and holograms. So motion marks and holograms are becoming simpler to represent. They were, when they were first starting to be trademarked, very, very hard for us to be able to distinguish and say, provide that accurate description. But given the changes in technology, you'll hear over the coming rest of today and tomorrow, technology and IP are so intrinsically linked. And the beauty of IP and IP law is that it moves all the time. And as technology changes, intellectual property laws, rules, procedures, and jurisprudence will also change. So now with the change of technology and the ability to use MP4s and technology like that, it's far easier to provide that long-lasting and accurate description of a hologram. So it enables us to be able to use these more effectively and to decide on trademarks when it comes to holograms and motion marks. So when it comes to filing directions, we have very, very clear descriptions on what can and can't be used and filed. This affects the enforcement a little less, because by then the filing will have already been completed, but we do try to provide standard filing procedures for everybody, again, to make it as accessible as we can to people starting out on their IP journey and as startups. So when it comes to these unusual marks, the test for legal distinctiveness is the same for 3D marks, sound marks, colour, and other marks as it is for the more traditional marks. Non-traditional marks are capable of functioning as trademarks, providing they have that capacity to distinguish the goods or services from those of others. There are also sometimes scent marks, but we only had one on the UK registry and they are particularly challenging. So as long with those other non-traditional marks, scent marks in some jurisdictions are able to be protected. In the UK, we don't necessarily have the ability to, because it's very hard to provide that accurate description at the moment still when it comes to scent marks. In terms of examination, we look at using the Nice classification system. So the Nice classification system was established by the Nice Agreement in 1957, and it is the international classification of goods and services applied for the registration of marks. There is a new edition since 2013 published annually, so that is updated on an annual basis. And there are 45 classes of and administrative systems within it, one on goods and one on services. I appreciate this is very small to be able to see, and we will provide slides afterwards by electronic format if that would help. But any application must satisfy the requirements of registration. And the questions which are in our diagram are the ones which our examiners would look at. Is it clear and precise? Does it have the correct classification? Is it containing a series of marks? We do also then consider bad faith, which is something I'll touch on in a second. So Section 3.1 in the United Kingdom's Procedures and Act is the one that really makes us able to decide, can we allow a trademark or not? And basically, will it work as a trademark? So if it is devoid of distinctive character, we can't accept it. Is it characteristic of our goods or services, so wool for carpets, pizza delivery for delivery services? We can't accept it. We also can't accept it if it's a customary and trade sort of description, so a 4x4 for a vehicle. Well, if we allowed one producer to trademark 4x4, we would have a lot of other 4x4 manufacturers who would be a little irate, understandably, at us because they wouldn't be able to describe their good in that way. So we have to make sure it's that distinctiveness that is key. So marks will generally not face objection under Section 3.1 if it has no direct good relationship to the good or service, and if it is merely elusive or suggestive. So suggesting in that it's to do with the car, we would be able to accept. However, what we cannot protect are signs that cannot be fixed. So you can't have that description which will be able to be read. If I read it today or I read it in 20 years, I would still understand that description. So we do, in theory, have smells, but and scent marks, but we at the moment don't have the ability to have that long-term fixed description of the smell and scent, which would smell the same now as 20 years' time. You can't hold a vapour in the air and keep it fresh for 20 years, for example, so we can't have that. We also then have criteria laid out in our 1994 Trademarks Act and associated rules. So we have a very clear direction around what we can and what we can't actually accept. So when we look at distinctiveness, distinctiveness is very subjective at times, and there are other ones which are very obvious. If somebody decided to have soap, well, soap is a general product around the world. We couldn't look after that. We couldn't have that as part of a trademark. It is totally generic. But then there is a spectrum, and this is where it can get a little more complex as to whether something can be granted as a trademark or not. So orange as a colour or as a description you couldn't have because it's generic. It could be used for many things. But if you associate orange with a phone, that would be considered unusual and distinctive. So orange as a company name for a mobile phone could be accepted because you wouldn't associate orange normally with a phone. So for it to be called orange and associated with phones is unusual, and it will make the consumer know precisely what it is they're buying. So there is a spectrum as to how distinctive it can be, and they are the ones which are harder and may then end up being ones which go through courts because they may be disputed around genericness. There are other reasons that trademarks can also have objections, or they could then be appealed. Some some marks aren't acceptable. So if it's to provide a function in the same way my colleague said about a 3-point plug for an electric plug, you can't trademark the three plugs on there and that picture because so many other products rely on it. It just wouldn't be fair. It's too generic. It's too in use. One which is particularly important, and especially in the realm of international trade, is ever growing, and that is bad faith. Bad faith marks can be quite a variety of different types of mark, but bad faith could be to do with somebody actually deliberately targeting. If they know a product's going to launch or a company's going to launch in another market, they could get in early with a trademark. They may have no intention of using that trademark, but it then prevents that company from being able to manufacture in another country. Or they then offer to sell the trademark to that company and hold it hostage. So bad faith marks within trade can be a real barrier for companies and industries when they're trying to move into other markets and need to be considered very, very carefully. However, in the United Kingdom, ignorance can be a defence. A bad faith mark, which is in a more malicious manufacturing sort of a commercial practice, that wouldn't be. But ignorance is considered a defence in the UK, and it needs to be overcome. And the most important thing, and one which is incredibly applicable across all areas here, are the World Intellectual Property Office treaties, conventions and agreements. Our initial speaker was very clear around all of these agreements which India and the United Kingdom and many other countries across the world are signed up to. There are some which are universal, and there are some which only specific people and rather specific countries will ratify and sign up to. So again, we always encourage know your market when we're looking at going out to export into different areas and regions. Make sure that you know which agreements are actually ratified and signed up to. Now, as I'm sure are aware, the World Intellectual Property Organization is the United Nations, and it's part of the United Nations which serves intellectual property. They look to promote innovation, and wherever possible, we try to encourage all people to engage at WIPO and all countries to engage at WIPO. And it's been incredibly heartening to work with the colleagues from the Indian government and other countries at WIPO. Now, for the Madrid system, you need an existing trademark or application in a member country. If you have to know that other party is a member of the Madrid system to be able to get that protection. There is also the Hague System and Cooperation Treaty, where a rights holder can secure their rights simultaneously in multiple countries or regions through one application in one language with one set of fees. And that's a really, really crucial ability, because especially in the world of international trade, to be able to do it with one language, especially if it's a language which you're more familiar with, it enables you to be able to protect and move your company on and to get that investment a lot quicker and in a far more simple way. To have to do an application across many jurisdictions in many different languages is an automatic barrier to trade. So these agreements are incredibly important, not just to small companies but to large companies as well. There are also things called a patent prosecution highway, a PPH, which is a voluntary soft law agreement, as opposed to these large multilateral agreements with many, many parties. You can also have patent prosecution highways, which are between two parties and two countries. Then we get to copyright, and copyright has many, many, many agreements and parts which you can sign up to. There is the Berne Convention of 1886, which I appreciate sounds like an incredibly long time ago, which it is, but it is still incredibly relevant even today. It lays down the certain minimum standards, including reciprocal recognition of copyright, a really important legal principle. It is also automatic, but it is advisable to make sure you register, as my colleague said, your copyright. In some countries, there is that registered copyright right, so if there is that available, we would always encourage people to take that registered copyright as well as unregistered. There is obviously the TRIPS agreement from 1995, which covers all World Trade Organization members, but that does require compliance with Berne. So if a country is not party to Berne, they're not going to be TRIPS compliant. There are lots of other WIPO treaties which impose further requirements and further copyright organizations and laws. There is then the Singapore Treaty, which is builds on the trademark law of 1994, and the Paris Convention, which was adopted, again, I'm going back in time a little bit, in 1883. So there are many, many treaties and elements of law which you need to be aware of when you're making this decision, when you're looking at whether somebody's appeal on a granting of a patent right is valid or not. And the most important thing is to have that holistic view of IP. It is very, very rare that you will come across IP which is singular and just affects one thing. It is intertwined in so many ways, and that's why we very much welcome the chance to talk about all elements of IP today. And on that note, I will pass over to my colleague.
Thank you, ma'am. The next speaker is Dr. Yogesh Pai from National Law University of Delhi, IP Foundations and Process. I would like to give a brief introduction about our resource person. Dr. Yogesh Pai specializes in intellectual property law and has research interests at the interface of IP with competition, trade, and economic policy. Dr. Pai is currently a scholar at CIP2 George Mason University, Washington, D.C., where he was previously the Thomas Edison Fellow from 2017 to 18. In the fall of 2012, Dr. Pai visited the School of Law, University of Washington, as the Asian Law Center short-term visiting scholar. Dr. Pai served on the roster of consultants with the World Trade Organization as a regional expert for regional trade policy courses and a tutor with the WIPO Academy distance learning program. Dr. Pai has been a speaker on intellectual property issues on different occasions and in India and in abroad. I request sir to please address us.
Thank you very much for the generous introduction. My lords, on the bench, on the dais of the dais, honorable judges, dignitaries, I'd really like to thank the Madhya Pradesh High Court and the Judicial Academy here, and also the organizers, collaborators, INTA and UK IPO, for inviting me to this training session. So I will pick up from where Ms. Sarah left us, but before venturing into some of the details, I thought I would do some conceptual foundations and try and see how we can approach the subject of intellectual property. As academics, we always try and do some conceptual digging into how these concepts are framed. So I'll introduce them to you, and then we'll move on to a bit of details about not all aspects of international IP treaties, but only those aspects that are relevant for intellectual property enforcement. And these are contained in certain substantive treaties. And the two foundational treaties Ms. Sarah had mentioned, the Berne Convention, the Paris Convention, although old as it may sound, but they have been revised until 1971 and then later subsequently incorporated into the TRIPS agreement in 1994, to which India is a party. So then we'll do some digging into trademarks law in India, some basic foundations, cancellation procedures, oppositions, process, bad faith registration, finally end with well-known marks. Let's see where we can go, because I can imagine that we will not have time to cover everything in detail, but I will just try and touch on the basic points. So we all know now that these laws can be structured conceptually into two. One set of categories of law that are to provide incentives, and the other set of categories of law to provide or to remove information asymmetries from the market. The reason being, patents, copyrights, and industrial designs or plant variety protection, semiconductor chip protection, etc., including common law trade secret protection, which allows remedies of breach of confidence, are designed around the idea that there must be some incentives that are granted to create that new product, or to come out with that new process, or to come out with the new designs or a plant variety, etc. However, in case of trademarks, geographical indications, and certain principles of unfair competition, for example, passing of remedies, we provide them not in as much as to provide the incentive to create the new mark as such, because that process is taken care of by copyright law, because artistic works could also be protected by copyright law. But the idea is that once these logos are created, etc., we want to protect the reputation and goodwill associated with those marks, not from just the perspective of the private company or the private right holder, but also, and most importantly, from the public policy basis that consumers should not be deceived in the marketplace. That's the foundational idea, and that is what divides these two groups of laws. So the economics of intellectual property is structured around the idea that knowledge products, information products, are essentially subject to non-rivalry and non-excludability. And what do we mean by that? In consumption. In case of tangible goods, let's take an apple. If I have an apple and if I keep half of it and if I give it to you, among all of you, you will have to share the other half, which means my consumption and your consumption put together is rival in nature. We can't consume the entire apple at the same time. However, knowledge products, essentially, because they are intangible in nature, for example, this lecture that I am delivering, each one of you is able to consume this lecture at the same time without being rivalrous, in the sense you do not deplete on the opportunity of each other to consume it, which makes it a kind of a public good, such as air or defense, because defense, we don't need to defend ourselves. There are defense forces to for the entire country, which provides us kind of coverage, security coverage. Similarly here, what you can see is that because of this non-rivalry characteristics, information without any inhibiting fetters can be subject to consumption at the same point of time by many people because it is non-rival. Second is non-excludable. If I have this, let's say a pen, and I give it to you, I can always take the tangible product back. I can always take the chattel back. I can always take the goods back. However, once I have delivered this lecture to you, because this is information, this is knowledge, I cannot dispossess you from this piece of information. It is now registered, and if I ask you to give it, I cannot take it back from you. But tangible products, you can always take it back. Because of these two characteristics, non-rivalry and non-excludability, while it is in terms of consumption, the problem is that for it to be consumed widely, it has to be created in the first place. And that's where the question of incentive comes. And that's the underlying principle based on which intellectual property protection is based, that you need some inhibiting fetters in the market to place certain reasonable limits on the transmission of knowledge. Why? Because in terms of producing commodities, be it goods or services, essentially you can produce, or anybody can produce existing goods once they are created in large quantities. But to create a qualitative difference in the market, to increase market share, etc., you would need that differentiating value or product differentiation. That is one of the essential characteristics based on which the market essentially functions. Now, why? From a public policy basis, you can compete in prices and output, because essentially if I am manufacturing a product that is not under intellectual property protection, let's say, forget about trademarks or any other kind of GIs, etc., but essentially in relation to patents, for example, or plant variety, if I were to produce something that is already existing where there is no intellectual property, and if I limit the output and increase the price, somebody else is going to enter the market. But in relation to intellectual property, because you want to value the differentiation created in the market, you are going to allow the IP holder to reduce the quantity and increase the price. Of course, this is also subject to competition. Future competition from other people who will, compete in quality, and also those people who will shift from your products to others which are closely substitutable. So this process is a constant process. In that sense, this is what is called as dynamic competition. Competing in prices and output is static competition, and competing in quality is dynamic competition. However, irrespective of all the differences between these two categories of laws, one of the essential elements is all these laws try and protect the differentiation element in relation to products and services, or in relation to entities and firms that are in the marketplace. So the unifying theory is differentiation, and the law has to protect that differentiation. I wanted to bring this slide to try and conceptualize as to how should we approach intellectual property law in terms of concepts. So if you were to divide any statute, patents, copyrights, designs, trademarks, GIs, whichever, then you will essentially see that rights and remedies are the core foundations of these laws. Rights in terms of exclusionary, mostly exclusionary rights, and they are bundle of rights, the primary being exclusionary in the character, in the sense of not allowing others to make, reproduce, etc. And the secondary bundle of rights in the sense of alienation, not allowing others to distribute, communicate to the public, offer for sale, selling, etc., which are more transactional in nature. So you have a bundle of rights that are segregated into two, and you have remedies that are structured around primary remedies being exclusionary in the nature, in the sense of injunctive relief, and or accounts for profits and damages. While injunctions naturally are equitable in nature, so courts may deny injunctions in certain cases. However, accounts for profits or damages are entitlements with respect to how the intellectual property owner can be compensated for infringement. Now, if these are the two core things, two core concepts that you are going to see in each intellectual property statute, each of these is also linked to the question of what should be the criteria of protection for any kind of intellectual property. In relation to patent, it would be novelty, inventive step, industrial application, and sometimes, for example, there would be a requirement to disclose, as a formal criteria, but not in relation to the invention itself. But this is also considered as a criteria of protection because it is mandatory. It's the quid pro quo of the patent system. Similarly, in relation to copyright, originality could be the basis or is the basis for giving protection to copyright. Originality in the sense that the work is coming from the author and it is not copied from anyone else. For trademarks, it would be distinctiveness, that your trademark has to be distinguishable in character. So in each of these categories of intellectual property, the approach would be to find out what is the criteria of protecting these works. And what kind of works? And we already know that patents are for technical inventions, copyright is for works. There are 6 categories of works, for example, protected under the Indian law: literary, artistic, musical, and dramatic works, sound recordings, and cinematographic films. So similarly, once you know what the works are, the second concept that you would find in any intellectual property statute is with reference to what kind of subject matter is protected or excluded from protection. So in relation to, for example, patent law, you have an entire longish section called Section 3 of the Patents Act and Section 4, which excludes subject matter. Similarly, in trademark law, you would see under absolute ground for refusal under Section 9, obscene marks, etc. are not allowed to be protected or registered. So similarly, you will see that in different statutes, there is some kind of subject matter that gets excluded. I think Justice Maheshwari mentioned Section 3D. Section 3D carved out those exclusions in relation to patentability of improved pharmaceutical drugs, wherein certain new forms of existing substances, unless they showed some kind of therapeutic efficacy, would not be patentable in India. So what kind of subject matter gets excluded is largely governed by the international framework, which we are going to see, but is also governed by, wherever there is flexibility, by public policy consideration, moral consideration, ethical consideration, economic and competitive considerations. So this is the second concept that you're going to see in each kind of intellectual property protection. The third is in relation to acquisition of IP, where it is mostly related to how you acquire intellectual property through either registration or sometimes through automatic protection or sometimes through prior use, because there are certain rights with reference to even people who do not register their trademarks. So acquisition process is the evidentiary basis of the existence of intellectual property protection, because it conveys in terms of whoever is allowed to file for those registrations, the ownership is conveyed in them, the first ownership. So acquisition concept is closely intertwined with the question of who can file and who can own the intellectual property after due examination by the Intellectual Property Office in India. Because these rights are territorial, essentially the examination has to be territorial. The other concept is, once you have acquired those rights, the question is about how do you transact them. And in all intellectual property statutes, you would see some form of procedural requirements with reference to registration of these transactions, be it licensing or assignment. And at times, there could be restrictions on what provisions can you include or exclude in terms of your contracts. Because once the property rights are crystallized, then the question is, through contract, can you impose certain kinds of conditions that may be considered sometimes as abusive? And in relation to them, for example, Section 140 of the Patents Act in India has a list of things that you cannot put in the contract because it is considered as inherently unfair, that might lead to abuse of the patent. Then you have the question of infringement, wherein mostly this is the job where the courts kick in. And that's when the question of whether the rights that were granted in terms of validity is correct or invalid, that would be the first question to ask. And then subsequently, there could be other aspects in relation to, for example, that the criteria was not followed, or that the there was fraud on the patent office, that documents required were not submitted, or any other kind of disputes that may arise out of licensing, which is outside the scope of license and hence would be constituted as infringement. But when infringement aspect is being dealt with, it is also important to consider that the law provides a lot of exceptions. Exceptions are of two kinds primarily. While in trademark, we do not have exceptions that allow compensatory uses by some third party. Why? Because the trademark would then be diluted or GI would be diluted. But in other cases like patents, for example, there are small limited exceptions for research, etc., which you need not pay compensation. But whenever there is a public interest kind of a situation, the law provides exceptions in the form of compulsory licenses. Or in copyright law, there are both compulsory licenses and statutory licenses, where in case of compulsory licenses, you would have to prove the grounds, but in case of statutory licenses, the statute already provides and assumes that there is a market failure, and hence a third party is allowed a license because the voluntary functioning of the market, that is, there is no license between the patent holder and the third party, so the government or the court kicks in and grants these kinds of licenses based on public interest. So there are these are compensated in nature, because compulsory licenses, when they are granted, they diminish to a large extent the rights of the IP holder, and hence compensation is a requirement. But in relation to limited exceptions, for example, we have in the copyright law section 52, where you don't need to pay any compensation for the uses that are mentioned there. So there are exceptions with compensation and exceptions without compensation. And then finally, this is where again the courts must take a careful look at with reference to where the jurisdiction lies. So there are many complicated questions with reference to where the jurisdiction lies, particularly because our offices are located in different jurisdictions, 4 different offices, or in other cases there might be additional offices that are created, and where the jurisdiction lies with reference to appeals from the patent office vis-a-vis the jurisdiction in case of infringement, wherever there have commercial courts been established, etc., can be subject to disputes. So this is how we can conceptually sort of classify. And if there is anything left, it would definitely be miscellaneous. For example, power of the government to frame rules is there in the statute, but it wouldn't fit in anywhere, so you can put it in the miscellaneous category. But all other kinds of provisions, you can fit into one of these criteria. So I will not dwell into now too much details. I don't know how much time I have. But I had a kind of a longish presentation on what the requirements in relation to IP enforcement are. Primarily, these treaties, which were signed and there were revisions made, they were subsequently cross-referenced in the TRIPS agreement. And irrespective of whether you are a party to these conventions or not, you would be required to comply with it, because the TRIPS agreement incorporates these treaties, mutatis mutandis, as they are. And thus, when India became a party to the TRIPS agreement, for example, India was not even party to the Paris Convention when we signed the TRIPS agreement. We signed TRIPS first, and then we signed the Paris Convention. But irrespective, we had to follow the substantive, provisions of the Paris Convention, because we signed the TRIPS agreement for various reasons, economic reasons mostly. And then, one of the foundational principles that this treaty align is a principle of non-discrimination. Non-discrimination is of two kinds. Non-discrimination with reference to your own national, because intellectual property is conveyed to people, IP holders. So national IP holders vis-a-vis foreign IP holders, there is a principle of non-discrimination. You can't discriminate. So whatever treatment you provide to your nationals shall be extended to foreigners. Second is the question of non-discrimination between two foreigners, two foreign IP nationals. So there the principle of MFN comes, which means most favored nations. In there, it is outlined that if you are giving, say for example, 25 years, 20-year patent protection for your own citizen, but 25 years you are going to United States, but to UK you are giving only 20. So UK can go to the WTO dispute settlement and argue that this is violative of MFN, although not a violative of national treatment, because national treatment is 20, UK is also getting 20. but because they have discriminated between two sets of foreigners, the MFN principle would get violated. So, why this is all important? Primarily because if you see many of these cases now, whenever they reach appellate courts particularly, frequently pleadings are made on the basis of our compliance requirements to the TRIPS agreement. And the interpretation that courts would want to draw then gets constrained with reference to what the requirement of these international laws are. And you can see in many cases, in fact, I'm particularly doing a study where TRIPS has been just referred and cited by lawyers, and then courts have observed that, look, this is the TRIPS provision. It looks like we have to then slightly interpret the, the national laws in compliance because we are members of the TRIPS agreement. So, because of the frequency in which TRIPS arguments are, put up before courts, particularly appellate courts, it becomes important to sometimes understand what the basic foundations of these agreements are and what do these agreements contain. Particularly, the thrust of these treaties are that they are private property rights. They don't use the word private property, but essentially, when they use the word intellectual property and they use the word private in the preamble of the TRIPS agreement, essentially these are private property rights. Or it is important to understand that the major requirement to enforce these rights lays with the private intellectual property owners. They are not in the sense, except where the states have to provide for criminal enforcement measures, etc., and sometimes ex officio actions, in the sense that the state says that they are going to, take care of counterfeiting or piracy because they want to initiate actions, suo motu actions. Only is those situations where the state would directly play a role, but otherwise these proceedings are essentially private in nature, in the sense they would be initiated by private parties. Now, there are various things that we can discuss in the context of IP enforcement, but TRIPS was the first agreement wherein intellectual property enforcement chapter was included in any international treaty of that scale, because it's a multilateral treaty with around 165, 170 members now. And the major aspects of these treaties are in relation to what remedies have to be provided by courts. While TRIPS does not say that in each and every case, the courts have to grant a remedy, for example, of injunction, or for example, grant a remedy of damages. However, the respective legislations in the parliament of those countries have to empower the judges through the law, which means judges shall have the power to grant remedies in the form of injunctions, damages, accounts for profit. Although courts themselves would not be required to grant them in each and every case. That's not the requirement in the TRIPS agreement. And this kind of flexibility within the TRIPS agreement leads to a lot of divergence between how injunctions usually are granted based on 3-factor or 4-factor test, including, balance of convenience, irreparable harm, and sometimes, public interest being considered as essentially important. Apart from civil and administrative remedies, it is also important to consider that TRIPS provides for what are called as border measures. And in relation to border measures, Customs Act in India provides for IPR enforcement rules, wherein goods that are imported into the country can be stopped at the borders itself. Criminal procedures are also outlined, but India has gone TRIPS plus way back in terms of providing additional measures in criminal law. So I'll just skip this and move on directly to trademark. So we don't have to essentially rely on the fact that our law draws from common law. Even prior to common law, the existence of trademarks in the Indus Valley civilization, or since the Indus Valley civilization, in the form of these marks and seals, to signify the distinctiveness with reference to their goods, was prevalent. But during the colonial period, when these enactments were extended to the dominion of India, and subsequently India itself enacting in 1940 its own act during the colonial period, and post-colonial colonial period, it was in 1958 when we came out with the Trade and Merchandise Act. Then it was repealed, and currently the Trademarks Act 1999 is the governing law. And one of the things that we can see is the framework that we took in terms of the trademark law essentially is from the 1938 UK Trademarks Act, incorporated into India in 1940, and subsequently the Trade and Merchandise Act and Trademarks Act 1999. Now, it is very clear to us, and Ms. Sarah has already explained to us the basics of trademark law in very detail. It is very clear that some countries may require graphical representation, while certain countries would do away with the criteria in certain cases. Graphical representation is important because it gives a public notice with reference to the existence of a registration of a mark. Otherwise, if marks were considered to be abstract or non-discernible, there could be no public notice with reference to whether the mark existed or not. It is important to understand that under the Indian trademark law, there are two kinds of refusals that can be maintained with reference to registration of the mark. One is with reference to absolute grounds for refusal, and the other are relative grounds for refusal. And similar to what Ms. Sarah mentioned, more and more descriptive the mark, less and less it is likely to be protected. More and more invented the word or the mark, more likely it is to be registered and protected. But as we know, even unregistered trademark based on prior use, where they can have acquired secondary meaning, can be protected under the Indian law. So, but unregistered trademarks, the protection would be limited with reference to establishing that there is goodwill, there is misrepresentation, and then there is damages, or that there is harm that has been done to the user of the unregistered trademark. Now, there can be direct passing off in the sense that you are using it with reference to identical mark with reference to goods. There can be indirect in the sense that you are making it deceptively similar. There could be reverse passing off where you are rebranding the existing goods of somebody else and selling them. So, in those cases also, actions would be allowed. I don't know if I have to stop or continue, but I have some other, aspects in relation to opposition. So, what should we do? It all depends on the time now. Okay. Very generous, sir. Thank you very much. So, the opposition system in India is based on the idea that once a trademark has been published in the journal, it is allowed to be opposed by any person for up to 4 months, and then there is a system of filing counter complaints. Then subsequently, by way of affidavits, there is a strict timeline where both the applicant and the opponents can make their affidavits. Finally, there could be a hearing, and post-hearing, either it is allowed, refused. There could be a review allowed at the registry for within a month with 1 month extension, and then there could be an appeal to the High Court with reference to the order that has been made by the trademark registry. The reason why opposition system has been allowed, because there is a fair chance that prior user rights with reference to whoever is existingly using, they are far superior in value when compared to the one who is registering it afresh. And the society at large should have the power to oppose these marks from being registered, or that they are in contravention with reference to the requirements of the law under the Trademarks Act. The cancellation is a system where the mark is taken off the register based on certain grounds, like no bona fide intention to use, non-use for a continuous period of 5 years. It may be if it has been abandoned by the registrar itself because of non-renewal, etc. Or based on the idea that absolute and relative grounds for refusal, they kick off, or that it is known or identical to a well-known mark. Now, the concept of well-known mark is very important, and we are going to briefly look at it. But what is bad faith? In relation to this, there is a very important Supreme Court judgment of 1986, which has defined the concept in terms of how bad faith leads to trademark trafficking. What does it say? Dealing in a trademark primarily as commodity in its own right and not primarily for the purposes of identifying or promoting merchandise. Because this was under the Trademarks Act 1958, the word used were merchandise. Primarily, if you are engaging in the business of taking trademarks, registering them, and then trying to keep your registration active for the purposes of selling it off without applying it with reference to your products or services, that could be a classic case of trademark trafficking. And these kind of bad faith registrations is one of the important and significant issues currently plaguing trademark regime everywhere. And that's why the process of trademark cancellation exists. There is furthermore jurisprudence in the context of bad faith. Now recently we have seen the decision of the Delhi High Court in relation to ghee products, Nova versus Novia, where primarily there were various reasons why the court said that there was both visual and phonetic similarity in terms of these two words, Nova being original and Novia being the other one which had picked up this mark and used it in the context of ghee products, both of them in the same business. But the court took note of the fact that there was an intention to deceive the consumers, because apart from the use of the word Novia, the trade dress, that is the packaging of the product itself, was deceptively similar to one that was existing. There was disregard to court process. There was also a question where, subsequent to the, there was abandonment of the trademark, and then there was adoption by the defendant. All these factors led the court to conclude that these kinds of trademarks that are registered in bad faith could be removed from the register of trademarks. I'll skip this and directly move on to final topic, that is well-known marks. So well-known marks have common law evolution. Even prior to signing of the TRIPS agreement, we had already recognized the concept of well-known marks. There were cases where the concept of dilution was recognized. One of the questions in relation to trademark is, because trademarks are registered with reference to specific classes of goods or services, and there are 45 classes of goods and services, what happens if the trademark has acquired well-known status? Why? Because it may or may not deceive the consumers in the market, but definitely the use of that mark extensively in other businesses beyond the class of products for which it is registered would lead to a situation where it could be diluted. And because the trademark of the owner gets diluted and there is harm to private property, the concept of well-known marks has been developed. So in NR Dongre, Whirlpool versus NR Dongre, we also recognize the question of transborder reputation. In this case, the fact of the matter was, although the product was not available in India, because of wide-scale advertisement, the court imputed transborder reputation and provided protection to well-known marks. I'll skip some of this now, and because I had been given 10 minutes. Maybe tomorrow when we discuss these in details during the enforcement sessions, some of these cases might again come up. We can definitely look for more information and material. The slides would be available. So thank you very much.
Thank you very much, sir. I now open the session for interaction. If the participants would like to ask any query or give any suggestions, they are most welcome. With the permission of the Honorable Chair, I would like to close the session. Thank you, my Lord. With this, we come to the end of the session. Yes. No, it's you can answer.
The FC UK brand was one that was quite contentious when it was put through, because it was one which, if you move the words around and move the letters around, it does make it a word which is not suitable for public use. So it was a case that was a particularly challenging one. I'll be honest, I'm not close to that case, but it's one I can find out about for you and on that behalf. But it is a consideration which in the UK we take very, very seriously. As well as that, we not just in terms of public offence, in terms of English language words, we also have to be very aware in terms of cultural sensitivity. So there's always a wider consideration when we are looking at whether a mark is appropriate or whether a mark is offensive. But in terms of that one, I'll be honest, I remember when that brand first sort of launched on the UK market, I was quite young and I was quite surprised to see it, shall we say. But it's a well-known brand. Yeah.
Any more questions? Thank you. With this, we come to the end of technical session 1. We shall meet tomorrow morning at 10 a.m. for day 2. Thank you.